Good afternoon and welcome to the September 4th Planning and Zoning Commission meeting. Appreciate everybody coming on an earlier start time than usual. I'm Chair Jeffrey Barton, and we will begin today with roll call.
Chair Barton.
Present.
Vice Chair Griner.
Present.
Commissioner Cycle.
Present.
Commissioner Wheatley.
Present.
Commissioner Bean.
Present.
And Commissioner Faircloth.
Present.
We have a quorum.
Thank you, Mr. Palmquist. We are also joined today by our City Council liaison, Maggie Ullman. Would you like to introduce yourself?
Hey, y'all. So, as is practice with our boards and commissions, City Council kind of divvies them up, and then we take liaison roles. And some commissions have more collaboration, some have others. Y'all are a special one as your quasi-regulatory. So, just recently, my peers and I discussed, and as Sandra is rounding out the end of her term in office, which we're grateful for, we made a shift. So this is my first official meeting. I'm excited to get involved more. In particular, much of the stuff that you all review comes to council at some point too. So a lot of the place I'm eager to really be in collaboration the most is we're working on the UDO and really redefining policy. So that's a place where I'm going to lean in a lot more as a teammate so that we can make some changes to policy that's better for the community, so I'm looking forward to that. And then also, as you all know, we're considering reappointments on Tuesday. We just reappointed our chair for another term. We're thankful. And so I know that as we get some new board members in, I think on the next meeting, we're going to review kind of the boards and commissions packet of code of conduct, ethics, kind of behaviors, because I do think that as this commission has more and more exposure to the community and is involved in more and more controversial things, we all just want to be very, very clear about what our expectations are of each other and how we serve. So that type of conversation I look forward to at our next P&Z meeting.
Thank you, Councilperson Ullman, for joining us, and appreciate that intro. Public comment for the regular meeting will be accepted by any of the following means. We accept public comment electronically by email in advance to pzcommissioners@asheville.nc.gov, and we all read these comments in advance of the meetings. In person, presentations by the public shall be limited to a maximum of 3 minutes for individuals and 10 minutes for a group's primary spokesperson. We'll hear public comments only on agenda items. All public comments, like I said, received in advance are read by the commission members, and we will not play them out loud or read them today, although we may allude to and reference some of the public comment that we received in advance of the meeting. We do also have one quasi-judicial item on our agenda today. So before we move into that agenda item, I'll prepare kind of some remarks about the process under the quasi-judicial rules according to state statute and our Unified Development Ordinance. So with that, we will kick off the formal agenda as we have for many months now with a land acknowledgement, and I will kick it over to Commissioner Wheatley.
Thank you, Chair Barton. Just real quick before I read our land acknowledgement, I would like to take a moment of privilege, and it is a privilege to serve on the board or the commission, and I'm really proud of our board in particular for taking the time to adopt a land acknowledgement. I am an enrolled member of the Cherokee Nation. My grandfather survived boarding schools, and for those who don't know, the motto of the boarding schools were to kill the Indian and save the man. And what that spoke to was the erasure of our people, not physically, but through ethnocide. And so by having the opportunity for a land acknowledgement, especially on our board that's focused on land regulation, is very meaningful to me, and I appreciate the opportunity. So on that note, as we are gathering today as the Planning and Zoning Commission, the body tasked with reviewing and advising on appropriate land use in the city of Asheville, it is fitting to acknowledge the storied history of this land. We occupy the land of the Cherokee people, who have stewarded and been in relationship with these mountains and waterways from time immemorial. This land is occupied through violence, oppression, coercion, broken treaties, and forced relocation. Please join me in expressing respect and gratitude for the present-day Eastern Band of Cherokee Indians, the Cherokee Nation, and the United Kidua Band of Cherokee, and all of our indigenous neighbors, as well as the past and present marginalized community members, as we seek to join in the healing of the indelible trauma that is embedded in this land.
Thank you, Commissioner Wheatley, and I appreciate your personal remarks kind of teeing that up. As I mentioned in our pre-meeting, the land acknowledgement has been, I think, an area of learning and growth for this board and the city at large. And to that end, following one of our duties as a commission in advising the city on potential amendments to the comprehensive plan, Commissioner Wheatley brought it to my attention that our comprehensive plan lacks a land acknowledgement. And in looking at the more recently adopted comprehensive plan for Buncombe County, they do include a land acknowledgement. Our comprehensive plan is kind of dedicated or centered with a beautiful poem by Mr. Dwayne Barton, which speaks to some of the themes of the tension of growth and development. But I'm seeking some guidance from this body on whether we feel it might be appropriate to explore a potential amendment to the comprehensive plan that would be a dedicated land acknowledgement. So any sort of feedback or questions? Not looking for formal vote. We don't have language right now. Just want to seek guidance on whether this would be something worth exploring.
I think it'd be worth exploring. I think it's a great idea. My personal opinion.
Thank you.
Yeah, I support it.
I'm in favor.
Great. So generally seeing some head nods. We'll put together some ideas in collaboration with staff. Appreciate staff's guidance on sort of procedurally how this might happen. So stay tuned for something in the coming months. Next up on the agenda, we have approval minutes from the August 7th, 2024 meeting. Before I entertain a motion to approve these, just want to note that we worked with staff to make a couple of additions to the portion of the minutes of the staff presentation last month. So hopefully you all have had a chance to review that really brief section that was added this morning. But any comments or questions?
I just want to kind of reiterate my appreciation for the meeting minutes being put in a more detailed manner, just because I know I have personally struggled, and I've heard of other folks struggle making it through, a 2 to 4 hour video on YouTube and trying to suss out the details. So this higher granularity in the meeting minutes is super appreciated, and I think it's far more equitable.
Any comments, questions, motion to approve the minutes?
I'll make a motion to approve them as amended.
Do we have a second?
Second.
We have a motion and a second. All those in favor, please say aye.
Aye.
Any opposed? The motion carries unanimously. Next up, we have updates from committee liaisons and work groups. Commissioner Wheatley, any update from multimodal?
So the last meeting of multimodal transportation, I unfortunately missed. I got an update from that committee kind of independently, and it was an in-person working meeting, which we talked about a little bit before. It's a really cool concept where they met at Burton Street Community Center and essentially got updated on new transportation plans and kind of just got to roll up their sleeves and get engaged with physical documents, which I think is really cool and a positive opportunity for staff and the commission to work together. So, Councilwoman Ullman, I know you're also on it. Did you have any updates you wanted to include?
It's a quarterly method that folks are really using to deeply get into the information. We serve on boards and commissions, but that doesn't mean we automatically absorb every page of every master plan. So this was a time to really look at a lot of maps, anticipate what's coming down the pipe, ask a lot of questions of staff. So it was like a shared deep dive in learning, specifically around infrastructure work that's happening by the city and planning work in the downtown area and CBD. So it was a really nice method and a lot of good information.
Great, thank you both. We didn't meet formally as housing work group, but anything to report? We did have a little bit of dialogue around the thresholds zoning text amendment, which is passed with unanimous support from Planning and Zoning Commission and is awaiting its city council hearing date. Have been hearing, a desire to include affordable housing as part of that. So I think I floated a proposal that we had a little bit of discussion about, and it seems like we'll maybe get staff follow-up next month in October about where that's headed.
There we go. Yes, right now we are intending to bring actually amendments for you to vote on to the October Planning and Zoning Commission meeting. That will be an update to the thresholds concept and focused on housing within corridors and mixed-use zoning districts.
Great.
I'm sorry, did you say October?
Yes.
Okay, I'm sorry,
Oh, you're fine.
working class ears, sorry.
Any other comments from Housing Working Group?
I don't have any update at this point, sorry.
No worries.
I just have a question. Would those, the revisions to the project level thresholds, is that kind of associated with like incentives, like the kind of existing incentives as it relates to affordable housing?
We're working as we speak
Okay.
on several options, but it's very likely what you see will include, at a minimum, what you have recommended with some incentives included on top of that. So,
Cool, really cool.
All right, we look forward to seeing that in October. I don't think I'm leaving out any liaisons or work groups, but anybody else have anything?
One thing I would like to bring up is that Urban Forestry Commission has some representation here today, which I appreciate with the later zoning text amendment that we'll review. I think both at the last meeting we discussed that some planning and zoning members also attended a UFC meeting, and am kind of wondering what level of engagement our board and commission may have with theirs, particularly as it relates to Chapter 7, and if we have any formal avenues we want to pursue there, or
Yeah, thank you for that reminder, Commissioner Wheatley. It's a great question. There are boards that have baked in formal liaisons, and Urban Forestry Commission is not one that has a formal liaison with the Planning and Zoning Commission. I think it's certainly worth exploring, especially as we're, on today's agenda, we have a zoning text amendment that has come through Urban Forestry Commission. I guess, would you all be interested in establishing that as a liaison? And if so, is there anybody? I think before we make a formal recommendation on who that might be, we should reach out to them and see if that's something they would like.
Yeah, I think it's a worthwhile discussion to have, because any amendment that comes through Chapter 7 comes through this board or is in Chapter 7, and so while right now it's UFC, it could be another board at any point in time, and so I think having some kind of whether it's an individual or just open conversations, I don't know if it should be formal or informal, but a way that folks feel like they could reach out to us in advance of amendments, making it here in a formal way to receive feedback and connect in more of a working group type setting.
If I may, since I have the opportunity to be a liaison to many commissions, this sentiment, but not the tree commission, or excuse me, urban forestry commission. I'll say the sentiment has lifted in other places as well, right? So multimodal has asked of this, the riverfront redevelopment. So I think that I encourage us to look at a lens of not necessarily let's adopt a formal liaison, which has a lot of actual infrastructure and volunteer time to it. But like, what is the problem we're trying to solve? And the solve being, where is this information flow going to be and how does that work? I know that at council committees, we're having that type of structural conversation as well. But if we lift up, because I think that, as you're saying, this ordinance has this implication for that committee, but as we go through this, there's going to be others as well. So I don't want to take up all your volunteer time with the first ones that we encounter, not to inhibit the intent of getting more connected and collaborated, but if we have a little bit more of a global lens, that might be really helpful if you continue that conversation.
Yeah, thank you for that. That's really helpful, and I think, yeah, I agree that there are plenty of other advisory boards who are, advocating for policy changes. So maybe we work with staff, extend an open invite to all of the advisory boards who are working on particularly Chapter 7 reforms to, come speak with us and involve us in some way so that we can help amplify their good work.
Yeah, I think, just kind of in the open dialogue, in the agenda, I don't know if the agenda is an appropriate place for it, but we have staff reports for specific project reviews and zoning text amendments and other specific items, but I almost wonder if there's not, like the same way we have the update from committee, it's almost like an update from staff, what Chapter 7 amendments are being worked on in the pipeline with those other committees. And, because it's kind of tough as a volunteer to like try and go out and connect with all the other boards or expect all the other boards to connect with us. Maybe UFC is the only folks working on Chapter 7 modifications.
Well, maybe I think a good way to handle it might be to kind of use our staff context to identify what fits in the work plans, what different advisory boards are working on, and then in an ad hoc manner we can plug in or solicit volunteers so that it's not, right, like an additional standing meeting that's added to our already busy schedules, but more of a task force relationship between a member of this commission and the other advisory boards. So I guess I'm not hearing kind of like a specific charge now, but how about I'll reach out to the current chair of urban forestry and as well work with our staff to get some insight on what might be coming down the pipe from other advisory boards. If that sounds good.
Could we hear maybe from staff on their thoughts on that? In Chapter 7?
I couldn't hear you very well, Commissioner Grinner. Could you
I'm
repeat?
gonna ditto that. If we can all get our mics like
Yeah.
4 inches closer, I'm struggling with every single word. So just help
I've
the
got a
video cameras at
reminder
home. It's got a reminder, so remind yourself.
Please speak into the microphone. I didn't say that, but yeah.
Bless you.
We're right in front of the white noise machine
I
here
know, me
too,
too.
so yeah.
So what I was saying, I wanted your opinion on that in terms of things that you all are working on that affects Chapter 7, how it relates to us.
In general, you are going to be aware of what's going on with Chapter 7 because that is the Planning and Zoning Commission's charge, is to approve and recommend all ordinance amendments to that section. 719, which you're going to see tonight, is a little bit of a different animal because this is a long time coming update that we've been working on tree canopy protection standards with the Urban Forestry Commission on for probably 2 years to get it right. So for some of you that have joined the commission within that time, it probably wasn't on your radar until recently. But actually, we've really turned over a lot in that time. But had you been on the commission back then, it was pretty well known that this was going to come back through for updates. But I mean, we're happy to add something just to a staff report generally to let you all know what's going on with it. I just don't want to overpromise. I don't think there's going to be a lot to tell you unless we have an actual initiative going on like we do now with corridors and centers that we've made you aware of, and you know when it's coming down the pike. Yeah.
Thank you. All right, that will kind of conclude this, the administrative section of our agenda, and head into our first public hearing. So as I alluded to at the top of the meeting, this next item is a quasi-judicial public hearing. It's a request for a special use permit for a group home located at 130 Rock Hill Road. The property is identified as PIN 9656-287379 in the Buncombe County Tax Record. The property owner is Lei Shi. The applicant contact is Mr. Carl Singletary. So in the review of this special use permit, the Planning and Zoning Commission will be acting as a quasi-judicial body in accordance with the North Carolina General Statutes and the City of Asheville's Unified Development Ordinance. We'll now begin the evidentiary hearings for the quasi-judicial item that is listed on the agenda. As a quasi-judicial proceeding, the Planning and Zoning Commission is not setting policy, nor are we soliciting public opinion on the desirability of an application. The Planning and Zoning Commission hears and considers evidence presented and applies the standards set forth in the Unified Development Ordinance, which for special use permits is Section 716-2C7, 7 standards for special use permits. The Planning and Zoning Commission must make its decision upon competent, material, and substantial evidence to determine the facts of the hearing. The Planning and Zoning Commission will use judgment and discretion to apply the standards contained in the relevant section of City Code to the facts. The commissioners, in voting for an item, will not have a fixed opinion not susceptible to change, have a conflict of interest, have engaged in ex parte communication regarding the application. So our rules for speaking on this item are that the meeting is open to the public, but participation is limited to interested parties who wish to provide comment and testimony regarding the proposal. If you will be speaking as a witness, please focus on the facts and how they relate to the relevant standards, not personal preference or opinion. Witnesses must swear or affirm this testimony. So at this time, I'll administer the oath for all individuals who intend to provide witness testimony. So please, anybody wishing to provide witness testimony on this agenda item, stand up and make yourself known. Please raise your right hand. Do you affirm or swear to tell the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. So now we will turn it over to our planner coordinating review for a presentation on this item. Mr. Palmquist.
Thank you, Chair, and good afternoon, Commissioners. Will Palmquist, Planning and Urban Design. This laptop likes to go to sleep a lot, so wake it back up. All right. I'll be presenting background information on this special use permit petition for the use of the property known as New Hope, New Beginning Group Home. So the site itself is located at 130 Rock Hill Road. You can see the location there on the aerial map and also the vicinity map showing it just a little ways off of Sweeten Creek Road in South Asheville. The site itself is about half an acre. The existing zoning is residential, single-family, high-density, RS8. So group homes are a use allowed in that district through the issuance of a special use permit. Group home is defined in the Unified Development Ordinance as a residential home provided by an agency, organization, or individual for persons who need shelter living conditions for rehabilitation, but not including mentally ill persons who are dangerous to others as defined in North Carolina General Statute, Section 122C, subsection 311B, This definition does not include family care home as defined herein. So just a reminder that in the special use permit section of the UDO 716.2C, there are the 7 standards against which all special use permits are reviewed. There's also specific requirements listed for group home uses in that section as well that have particular requirements for the siting, design, operations, and buffering of other group homes. We'll get into that a little bit more in this presentation. And then just another reminder that per the amendments adopted in January of 2024, the Planning and Zoning Commission makes the final decision on special use permits in a quasi-judicial hearing that we're having this afternoon. So the project site is the current location of a group home known as New Hope, New Beginnings. So this is an after-the-fact approval of a special use permit. The group home had been operating for several years without zoning approval for the change of use from a single-family residential. So this application for a special use permit is a result of that zoning enforcement notice of violation that was issued end of last year. No new work or site changes are proposed as part of the special use permit application, so there's no site plans or anything to show. Though the staff report does have the plat and survey of the property attached in the exhibits. So I mentioned earlier there are some very specific requirements for group homes that operate under a special use permit, such as things like the location and the setbacks and the character of the building that they're located in and so forth. As part of the special use permit process, the Planning and Zoning Commission can grant technical modifications to those requirements. So there are 2 technical modifications that the applicant's requesting through this special use permit application for the group home. So they are listed here, and they include the first one being the allowance for a total of 6 parking spaces in the parking lot at the front of the building, where the maximum is otherwise limited to 2 spaces, and also for the allotment of 2 front entrances to the building, where 1 front entrance is allowed per that section. So these are the 7 special use standards by which all special use permits are reviewed against. The applicant has submitted written testimony in advance of the meeting of how the group home would meet these standards. So that's been available for your review as well. The staff report lays out the other technical review elements of the group home as relates to the specific zoning requirements. I'd be glad to answer any questions you might have, or if you'd like to turn over to the applicant for their testimony as you see fit.
Just one question on the parking requirement. Can you explain the maximum of 2 spaces is quite low compared to some of our other parking maximums? Can you explain that UDO provision?
I guess I can kind of speculate maybe on why that is a requirement or a limit. A lot of the special requirements in that section relate to design elements that require the use of a group home to look like a single-family house, more or less. So location of driveways and the size of the building and the character of it. So in my mind, it would make sense that the requirement limiting 2 parking spaces in the front, kind of like a typical house with either a wide driveway with 2 areas for parking or stacked parking spaces. Probably the intent is not to have a very large parking lot and make it look like commercial use. The idea is that the group home would blend into the neighborhood. So that's probably why that requirement is there. The current use does have those 6 parking spaces, so the applicant's requesting to have that modified through this hearing.
Okay, thank you. Any other questions for staff before we invite the applicant?
All 7 requirements are met.
That's for us to
Yeah.
determine.
Staff has analyzed that in the staff report. There are two requirements typically that require expert testimony regarding traffic and property values. So staff, at least I'm not qualified to speculate on those elements, so we have no response for those. But staff has given their opinion on the other five.
As I noticed, with the plat and the survey, there are no contours on the survey. Topography was given as a site constraint. I was wondering if staff was able to review topography without there being a survey.
I think more from just seeing it in person and photographs and such, based on the current siting of the house structure, and kind of how the just looking at it from the viewpoint from the street, but we did not do a topographical analysis or have that information at a more technical level, I guess.
Thank you.
Mm-hmm.
On the, you mentioned the two standards that staff wasn't in the position to offer any feedback on. One of them is the standard that the proposed use will not substantially injure the value of the adjoining or abutting property. This may be a question for the applicant. They have said in their response that the higher property value for this property will certainly help neighboring property values and higher property taxes revenue for the government. Was staff able to corroborate that this parcel, in fact, has a higher property value than its surroundings from the Buncombe County tax records?
I do recall checking that, and I recall verifying that information. It was several months ago now. I can say I do remember double checking that information. So as long as it's still that current information, I did confirm that property value that was listed in the responses, which is, yeah, so that is something that I think we could consider. Well, I'm not going to say if we consider testimony or not, but I think it would be confirmed in that way.
Okay, and then this may be more a question for our legal staff. Is that, in your view of special use permits, acceptable standard? I guess in our last one we had an appraiser, and that's sort of the more conventional approach to demonstrate property values won't be impacted, but just using the higher assessed value by the taxing authority, is that?
Yeah, and we don't even need to get that specific. There's a specific exception in the case law that says that the owner of the property...
Sorry, could you speak into the
Sure.
mic? Yeah.
There's an exception in the case law on quasi-judicial review like this that says that the owner of the property is always allowed to testify as to their belief or opinion as to the value of the property. So that's something they have the right to do. What they choose to base that on is that might go to your interpretation of how much impact it has, but that's a clear right that the applicant has. They can always say what they think their own property value is.
Great, appreciate that, thank you.
Can staff, I mean, this group home's been, if I'm reading the materials correctly, has been in operation for some time. Like, can we get a background on how this came to this point? I mean, was it a neighborhood complaint? Was it a tax catch? Or like what triggered all this?
Sure. So yeah, I think it's fair to say most of our zoning enforcement activity in the city of Asheville is complaint driven. So zoning enforcement staff was alerted to this group home operating at this property. They checked against the approvals on record for what was allowed to operate on that site, and found that there was not a approval for a change of use to a group home. That the most recent change of use had approved it for the use of a single-family house. So that would be the only use that was allowed at that location. So zoning enforcement staff worked with the applicant to and with planning staff to suggest an avenue to get approval for the use of the property. Planning staff identified the use to be most similar and accurately described as a group home, which is allowed by a special use permit. So that was the avenue for getting compliance and having the property out of violation of the zoning that we identified with the applicant as as an option for having that enforcement taken care of.
Okay. And then as far as like just time frame, I mean, I'm imagining this isn't like an overnight thing. There's a notice of violation working with the applicant. This takes weeks, months, years. I mean, how long has this been playing out?
So the notice of violation, I believe, was issued at the end of October of
Okay.
last year. So yeah, I've been working with the applicant and have been in communication with zoning enforcement staff about kind of the progress of that. And as you know, it's been continued a few times at the applicant's request. And so the city has not taken any further enforcement action like a citation or anything like that, because we knew the applicant was working to have it be reviewed by you all. So it's kind of stayed that enforcement in the meantime.
Okay. Thank you, Mr. Palmquist.
You're welcome.
Thank you. If there's no other questions, we will now invite the applicant. You can come up to the mic, please. And please state your name when you get to the mic.
My name is Robert Kaplan. I'm here as an advocate, and make this very clear, I'm a licensed attorney in Wisconsin, as considered as active, and because it's quasi-judicial, I can't represent Mr. Singletary. Mr. Singletary is here to testify, and I would also like to reserve the right to question Mr. Palmquist after Mr. Singletary testifies. Carl. And the issue, and I just make this clear for
Sorry,
the board.
please speak into the mic. Just,
Okay. To make this clear, the issue is whether this is a group home, because it is our position it is not a group home. The city planning has done it improperly. They have never notified Mr. Singletary. They've never notified the owners. The property records do not show it as a group home. It is not a group home. Mr. Singletary is qualified to testify as to what is a group home. Mr. Singletary.
So understanding that the application before us is a special use permit that would
We're
qualify
opposed
this.
to it.
So you are seeking to not have the special use permit?
No special
approved.
use permit, and the board needs to send this back to the city to have it recognized it is not a group home, it is transitional living.
So
And-
what you're seeking today is not, one of the outcomes that's outlined for us. We can, if you are asking for, we can request a continuance so that staff can continue to work with you, but it is, I believe, staff's position that the rezoning application would be the avenue to bring you into compliance.
Well, my position would be that it should be continued and referred back to the city planner to review whether it in fact is a group home, because when you look at the definitions of a group home under federal statute, under state statute, under even a general Google search of group home, this is not a group home. It is transitional living, similar to the Oxford houses, of which there's more than 20 in Asheville, similar to the Silver Linings houses, which are abundant in Asheville.
So I understand the claim, and maybe perhaps before we hear from Mr. Singletary, it would behoove us to hear from staff on the most appropriate course of action, because what you're describing has not been presented as evidence under the current request, which would be to grant the special use permit for a group home. So I understand what you're
Okay,
asking for.
thank
I
you.
just want to procedurally make sure that staff is able to respond, because what you're describing has not been presented as evidence in the materials we have in the application packet. So
When I can make this clear to the board, we asked that there be discussion of whether this is a group home or not, and the city planner would not put that on this agenda for today.
Understood.
So I would like you to refer this back to the city planner, continue it for at least 30 to 60 days.
could staff respond to these claims by the applicant's representation?
I might jump in just because this is going in a direction where I think everybody should be clear on what's happening. So the determination of what is or is not a group home is a zoning determination. Determinations of whether that's correct go to the city's Board of Adjustment. those appeals to the city's Board of Adjustment also have to happen within 30 days of receiving that determination. And if they haven't happened within 30 days, they're affirmatively barred under a legal doctrine called the failure to exhaust administrative remedies. So the notion that the city could go back and have an appeal heard, our board wouldn't have subject matter jurisdiction to even hear such an appeal. And so that route seems to be foreclosed by operation of time and what's before this board. And the only thing it can hear is a special use permit, which would address the concerns. But now we're hearing that you may not wish to present evidence in support of the application that you've made for a special use permit.
No, we do not support it. And to clarify the city's position is there was supposedly a determination that this was a group home, but there was never any notification sent to Mr. Singletary, the owner. And when I looked in the property records last week, it does not show that it is a group home. It is that I could find in the city property records. So the problem I have is I think the city, somebody thinks they made a determination it was a group home, but the notification was not proper, and therefore it is not. It's not only not appealable, it's not applicable at all because it was not done properly in the first place. And just to further emphasize that, in terms of making a determination for a group home, nobody from the city has ever come and looked at the home, gone inside the home, talked to the residents to see if in fact this is a group home. Never was that ever done. And Mr. Singletary can testify to that matter as well. So the bottom line is, from my perspective, you know, the old legal adage, as you're aware of, is it doesn't pass the smell test. And because it doesn't pass the smell test, this needs to go back to the city for further resolution and for further discussion with Mr. Singletary and make a proper decision if it's a group home. Because when you look at a definition of a group home, and you start with the USC code, you look at the USC, it clearly is not a group home. It's just a place for people to live when they come out of prison.
I understand.
So, may I ask a quick question, Chair?
Yes.
Of staff. Staff, I'm digging around in these documents and trying to just find it myself and failing miserably. In our use table, do we have a transitional home use?
I don't believe so.
No.
I'm not familiar with us having a transitional use or a transitional home use. And so
think that's
it
correct.
sounds like there may be a definitional issue. And it sounds like staff has reviewed the uses that are applicable within our municipality. Is that correct?
Just one moment.
I'm just trying to, because, you know, we can't assign new uses. We can't just make up new uses.
That's correct.
So staff's determination was group home is the closest applicable use.
That's correct.
And could you speak a little bit to how that determination was made? It sounds as if the applicant, you know, didn't understand how that determination was made. And again, you know, this is kind of outside of what's before us, but we're here, so.
Sure, is that appropriate?
Yep, it's fine. You may also want to clarify when the NOV was sent and what it contained.
Right. So essentially, zoning enforcement staff went out to the property and based on their observation of the property and any other follow-up discussions with the operator of the use of the property, determined that the use of the property was not a single-family house, which is the only use that is allowed at the property currently. Therefore, the property is in violation, and they issued a notice of violation to let the operator of the business or use of the property and the property owner know that there's a zoning violation. Zoning enforcement staff, myself, Assistant Director Chris Collins, who is acting as a zoning administrator as well, worked with our internal staff and then reached out to the applicant and let them know that, and through understanding the use of the property, that a group home would be the closest definition fit based on our table of uses, and let them know that a group home is allowed by a special use permit in the district, in the zoning district, RS8, so no rezoning or conditional zoning would be required. They could simply file for a special use permit, which is what the applicant did. They submitted an application for a special use permit for the group home. So staff began preparing for the review of that. And it's taken a while to get here. That's essentially what happened.
When the zoning enforcement officer visited, did they have access inside the facility or just kind of looking around the grounds? Talk a little bit more about that determination.
I can't say for sure since I wasn't there and I don't have full accounting of the events, but they are, however they typically handle that is so I can't answer that, I guess, is what I'm saying, yeah.
And then looking at the special use permit application that was included in the meeting materials, I'm trying to find somewhere where the applicant is agreeing to or affirming to the determination of group home. I'm not seeing it in this application, but could you direct me to where that might be?
Mr. Barton, I'd like to add why this is an important issue. I think as many of you know, the Asheville community in Buncombe County has been very, very supportive of the recovery community in general. And this is a significant issue because it affects the entire recovery community. It opens Pandora's box for the city to come in and then say, we're going to make all these recovery houses group homes, which they are not. If you look at the very first line of the U.S. Code regarding group homes, it's clear. The term group home means a single-family residential structure designed or adopted for occupancy by not more than 8 persons with disabilities. The people living in this house do not have disabilities. In the situation at 130 Rock Hill Road, the residents are people who have been released from jail, from prison, who are transitioning back into society. And the philosophy throughout the country is that people in recovery houses are to be integrated into the community and not to be singled out as something different. And to do so would be a travesty for the recovery community and a travesty for the city of Asheville. And that's why this matter needs to go back for review. The problem is, and Mr. Palmquist and I have discussed this, along with Attorney Ashley, is that the city is trying to put a round peg into a square hole because there is no definition of transitional housing in the city code. So I would urge the board to say, look, this is not where we want to be. We need to go back and review this matter. As I've indicated to Mr. Palmquist and Attorney Ashley, I'm more than willing to spend the time, which I'm doing pro bono for Mr. Singletary, to spend the time with them to try to come up with something that would be appropriate for city zoning, because what we have now is not appropriate. And it's important that if the city wants to go in that direction, that it be done appropriately and then come back to this board for approval.
Thank you for that. I appreciate Mr. Palmquist.
To answer that question, Chair. So the mention of group homes is not explicitly made in the application. It is referenced in the applicant's response to the standards of the special use permits. You're correct that the application itself does not specifically say group home. It just lists the name of the business, New Beginnings, New Hope, New Beginnings. But there's reference to group home being in the applicant's response to the standards that we requested as part of the application.
Okay. I'd love to solicit kind of the feedback from the rest of my fellow commissioners, but
Yeah.
speaking for, go ahead.
No,
Commissioner
I
Cycles.
just, So the applicant, provided a definition of group home from other sources, and what I'm hearing is that there's some level of connotation that wants to be avoided. Is that
Right,
correct?
because what the problem is, if you're designated as a group home, it also implies that there's going to be some application of North Carolina statutes. The North Carolina statutes per se do not define a group home. The North Carolina statutes define an adult care home, which is a pretty similar definition. But it's not a group home under North Carolina statute. But the concern is, if this is a group home, the state's going to come in and say, well, Mr. Singletary, you can only have 6 or 8 residents, which will make it monetarily not feasible for this particular residence. And Mr. Singletary would like to have an opportunity to testify. Mr. Singletary, by the way, who is the owner, is a certified drug and alcohol counselor, but he does not provide any professional services to the people living in this house. He just manages the house and runs the house. But it is a serious issue that needs to be further studied.
Yeah, what I'm hearing is there just may be a disconnect of definition, because our UDO does define group home, right? And the definition I'm reading right now from 725 definition says group home means a residential home provided by an agency, organization, or individual for persons who need sheltered living conditions for rehabilitation, but not including mentally ill persons who are dangerous to others. And that's the simple definition. And so, I mean, if we think that this falls within that definition, then within the means of our UDO and our use table, that this would be the appropriate application. But what I'm hearing is there may be a incongruence with the interpretation of group home between our
is
UDO
correct.
and other sources.
Right, that is correct, because the definition in the Asheville Code is significantly different than if you look at the U.S. Code, the North Carolina statute. If you look at the code from other municipalities, which I have, it's very different. And this definition that we have is just really off the beaten path as far as I'm concerned. And, like I say, it's a serious issue, and if the city wants to address it, that's fine, and we're willing to spend the time to do that, because it affects tremendous number of properties in the city of Asheville, because we have a large recovery community, as probably most of you know. And it's just a travesty to say this is a group home. The men who live there don't get any services. They make their own meals. They don't have disabilities. I don't consider somebody who's released from jail and transitioning into society as having disabilities.
Yeah, and I agree with you 100%. I would hate for that connotation to happen, because, you're correct. And anybody transitioning from prison or rehabilitating from addiction does not have a disability. I agree with you 100%.
Thank you.
That language is not in our UDO, though. And so I'm just wondering how to proceed, because the group home definition within the UDO is exactly what I said, and it's just providing sheltered living conditions for rehabilitation.
With people with disabilities.
It doesn't say that in...
I believe, let me see what it says. I thought it was up there. Is it up there? No, it's not up there. Okay.
Legal,
have it, yeah.
I have a question. Did you review the North Carolina general statutes as it relates to if it includes definitions around a transitional home?
No, that would not govern our zoning review that's before you today.
The general statutes like 160D or anything like that?
Yeah, they typically don't set out mandatory definitions that municipalities have to adopt, and so when we have a definition that's provided for, as Commissioner Cycle is mentioning, that's really what we're looking at. Whether that definition is fair or right or most accurate is something that this board might look at as a legislative matter in recommending amendments to the UDO, but with a SUP before you, an argument that our definition should have been something else and that would have helped them is not relevant to the application.
I think that's helpful, and I'm glad that we are having this conversation today because I think we've all been in the dark about why this item has been continued so many months, and so now here we are having the conversation. Personally, I don't know how we have a path forward today simply because we are being asked by staff to consider a special use permit despite the applicant's wishes. I don't know that that's ever happened. Usually we're considering conditional zoning, so maybe just procedurally, could you kind of talk about under special use permit, is it appropriate to proceed with an application that the applicant is not supporting?
The applicant is always permitted to withdraw the application, and they could do so. They could request a continuance. That would be something that you could grant and move it to another time. Oftentimes, boards will only grant so many continuances, but we're having a full-throated conversation that's seemingly resounding and is helpful. So that's an option available to you. If the ultimate desire, though, is for this board to mandate that the Board of Adjustment take up an appeal that it lacks jurisdiction to and never could again, it's going to be problematic. And so again, there's a mechanism before this board on how to correct the problem within the definition of group home that exists in our ordinance. And there's not a mechanism anymore because of the operation of time and the failure to appeal an NOV within 30 days. So I'm just saying again and again, it seems like there's a golden opportunity before us to address this head on and deal with the issue in a way that might be helpful. And that option really doesn't exist before a board that no longer has jurisdiction.
Okay, counsel, then are you saying that the issue about the group home can still go to the Board of Adjustment?
I'm saying the exact opposite. That
Okay,
if you've received an NOV,
because the problem, though, goes back to the fact that there was not proper notification to Mr. Singletary or to the owner of the property, or even in the property records. Go into the property records.
So
It doesn't say anything about a group
I
home.
appreciate that information. It's kind of outside of the purview of what's before us today, but what I'm hearing, and I would love to hear Mr. Singletary speak on behalf of the application or the request, what I'm hearing is that the proposed remedy that staff has prepared responses to the application around is not the desired or perhaps appropriate remedy for this type of facility. It highlights yet another crack in the UDO, and I'd be inclined to entertain, the legislative fix that council has alluded to, rather than what may be perceived by the applicant as like a Band-Aid fix that could trigger cascading impacts beyond this current application. That's sort of where I'm at.
Yeah, I'll just say that we've considered that suggestion by the applicant, and I don't think at this time staff would be inclined to modify our definitions or the UDO at the behest of the applicant. Staff feels that we have a definition for the use of the property that we think is actually a very good fit for it, and so I'm just saying understanding that, I don't think we would necessarily come back next month with an amendment to the UDO based on the applicants. And there's a
Understood. Based on this applicant, would
Correct.
Staff be open to seeking guidance from the state and perhaps other municipality? We're just doing a scan of how other municipalities have handled this very issue of recovery homes within
Right, I think
single-family neighborhoods.
the concern is the stigma associated with the term group home. The definition itself, I think, fits very well with the use. I think it's just the stigma that we want to consider possibly exploring removing from the UDO.
He also said it opens up regulatory state issues, correct?
that's
As far as
So
this meeting's concerned, though, we can approve, we can deny, we can continue this application.
Yes.
And if staff or the commission sees fit to continue the conversation on outside of this hearing, then we can do that. But at this point, we're either approve, deny, or continue. And I think, if we want to travel through this applicant's hearing, and they would like to pursue the hearing, then we can approve, deny, or continue. And I think that's an appropriate thing to do at this time.
The concern I have, Mr. Wheatley, is that is trying to find a mechanism to correct a fundamental error that the city made in saying that we are classifying this as a group home, but not giving any particular notification to anybody.
Understood,
And
yeah.
that is a fundamental problem of due process, of not giving the proper notification. And I would challenge the city to say, where is the notification that was sent? There wasn't any.
I think that's a separate legal action.
And if need be, I would suggest to my client to take it to
so-
Superior Court.
Yeah, so I think you can request we hear it and approve or deny, or you can request to continue, but we can't hear a request
Correct.
to re-legislate our UDO.
Okay.
So that's, I think, where we stand.
Would you like to speak, Mr.?
I don't know if they have any questions for me.
Go ahead. Why don't
Any
you-
comments?
Yes, sir.
Just, Mr. Singletary, thank you for appearing today and appreciate this, discussion. Do you have anything to add relative to your?
No, it's just that, like I said, we are considered a recovery home. We deal with substance use clients coming out of jail, detox, treatment. We've been operating for 7 years. We have no problem. I really don't know where all this came from, because it just came all of a sudden. And like I said, we have been providing that kind of help for this community for over 7 years and been very successful. So it was just very challenging when it first came to me, because I've been doing this since 2007. I have other facilities that we also have that we run in the same thing. And we never had this kind of challenge with those facilities. And it's just kind of, just dropped in my lap, and I didn't know what to do.
Yeah.
I've never, been through this process, and I've been doing this since 2007. So, we're just trying to help the community, keep people off the streets, crime down, just trying to do our part. So that's all I have to say.
No, thank you so much. I appreciate, the service you provide to the community, and it's particularly difficult work that you've embarked on, so thank you. And I also appreciate, your willingness to highlight some challenges with our zoning processes. I think we're all learning how to make improvements.
Yes, sir.
I don't know if I heard a response to, does the applicant desire a continuance on this, understanding like this board is not the one to speak to the notice, whether it was done properly. What we're reviewing is an application for a special use permit.
So we do a continuance. We'll ask for a continuance.
In light of that, and knowing that, this application has been on our agenda for 6 months, probably, maybe 8, almost all year. Can we continue this to, it doesn't sound like this application is really what you're desiring. So the application, in that case, could be removed, and then it would be removed from our agenda. That would be,
But then the applicant would be subject to the zoning
I would
violation.
agree with that,
and
Mr. Wheatley. I would agree. You can remove the application. But let me make one other further point, is if city planning made a determination to say it's a group home, there is no reason why they cannot take the initiative to say, we made a mistake and we're going to review it again. And that's what we're trying to do, is to get them to review it and to find whatever the proper channel is for them to review it. Because there's nothing that says they can't go back and reverse their own decision.
Staff, would you like to?
Just to outline a few things we've talked about and make sure everybody understands where things go if this application is no longer in the works. I think all of you understand, I've heard that we have a certain set of laws that guide how we define land uses within the city of Asheville, and we have determined that the closest definition we currently have is the city's definition of a group home, notwithstanding anything that may be out there in state statutes and things like that. A notice of violation that was issued and return address green cards returned for showing receipt to the property owner does cite the property for, but does provide a notice of violation for not seeking a permit for that change of use. If this application for conditional use, special use permit is no longer active, then we are no longer able to continue a stay on the proceedings of that enforcement. And it would have to move forward through that process. So I just, at the suggestion of removing the application, I just want everyone to be aware of the repercussions of that.
Does the applicant understand the?
I understand. I understand what Mr. Collins is saying, but the other thing is, this board, I think, would have the authority to say we're going to continue this matter, but you can still direct the city planner to go back and review his initial decision, because that is the decision of the city planner.
I think what we can do is, at the request of the applicant, we could entertain a motion to continue.
Okay.
It would come back on our agenda, and I would ask that the question of the determination of whether or not this is a group home be resolved between staff and the applicant,
And we'd be
because that
happy
would
to do
be
that.
outside of really the jurisdiction of our consideration of the special use permit.
And Mr. Barton, we're more than happy to do that. I've talked with Mr. Palmquist a number of times, and I'm more than willing to sit down, discuss it with him and Attorney Ashley to come up with what would be an appropriate definition or even an appropriate modification to the code for transitional living houses. And then I'm more than willing to do that, and that's what it should be.
So understanding that, it sounds as if the applicant's seeking a continuance. Is staff amenable to that? It sounds like there's a gulf in the application and understanding of the appropriate definition. I'm not entirely confident that that will be resolved via continuance, but I also don't know that, I don't see a way for us to proceed without the support of the applicant today.
We would be happy to explore it, given the limitations of what we have for available tools. If that's the direction we want to go.
With that, I'd like to entertain a motion to continue this item to date certain.
So just to be clear, before we entertain this motion, the definition that staff has proposed is in Chapter 7.2.5 of our definitions is in alignment with the current use. The application is put forward for that use in the zoning district. It has a special use opportunity. There's some regulation at the state level you're claiming which doesn't allow you a high enough occupancy.
Correct.
So we will not be able to fix that, and this hearing being continued doesn't fix any of those issues.
Agreed. I think what it does is it provides an opportunity for the applicant to talk further with staff, potentially withdraw the application if there is a more appropriate remedy. If it comes back to us, we're looking at the application we've received, which would classify this as a group home under the current UDO definition.
Yeah, I'd just like to be clear with the applicant. Should you put in, should you work with staff and find a new definition, there's by no means guaranteed that transitional use homes would be allowed in RS8 under any circumstance.
I would agree with that, Mr. Wheatley.
Okay, so I just want you to know that.
I think it needs to be discussed because there is literature on what is considered transitional living. There's a significant body of literature on it. And I would be more than happy to share that and discuss that with Mr. Palmquist and his staff. Because we feel that it's important. It's a large community in Asheville that's affected. And if we're going to do it, let's do it right. And that is what I'm interested in seeing it happening.
Okay, so with that, I would entertain a motion to continue this item to date certain October 2nd. Would anybody like to make a motion?
October 6th.
If we move to just deny this request, then hypothetically, then the onus is on the property owner to deal with the situation because they currently are in violation of RS 8. And there's some, I'm assuming there's some kind of time frame for how long they have to deal with.
So,
I'm just talking
yeah.
hypothetically, I'm
Yeah.
not making a motion. I'm just trying to understand, like,
What I was explaining before as to the 30 days that run after a notice of violation is issued. That's the time frame. And so if you don't appeal within that time frame, there's a doctrine of law called the failure to exhaust administrative remedies where they can no longer come to any board with the city and talk about it. And so that option's foreclosed to them. This is truly absent convincing, not this board, but this board and city council hypothetically to change the definitions to allow for this specific use in some other terminology. This SUP is the only mechanism of correcting this. And so if they don't want to proceed with this case, that option's, that's a choice they can make, but it's a choice.
But it's,
I guess
Am
the
I allowed
point,
to chime in as the liaison?
Absolutely.
well,
Then I would like to.
Especially since this gets to the notion of whether there would be some sort of legislation that would just change the status quo such that this problem goes away. I think it might be useful to hear from a member of the city council who is of that
agree.
legislating body.
yeah, I agree with that.
So I have a handful of thoughts. One, I'm really grateful for the work that you're doing. People need that hand as they're making a major life adjustment, and you seem like, as you've expressed how you started this work, you're just trying to do a good thing. And I hope that wherever this goes, it lifts up people like you to do good things for your neighbors. And we have rules, and so we want to figure out, okay, you started this effort up. We now know that the current rule set is out of compliance with the use that you're doing. So what do we do about this? So I hear what you're saying on your teammates' behalf about the stigma around group home versus transitional home is real.
It's not so much a stigma, but it does. But what it does is, partially it's a stigma, but partially then it puts it under the guise of state regulations.
For what regulations? For health code or for assistance for the support? Because there's no
The-
zoning or regulatory
Right,
regulations
it's
that
under,
it
I
triggers.
think it's under, the statute, I believe, is 131D-2, I believe is the correct statute.
And what type of policy does
Well,
that connect to?
because then what the statute does, it permits the Department of Health to go ahead and impose different regulations because they're assuming that there's people living there with disabilities.
Got it. So maybe it's like, how's the food refrigerated, things like that. So it triggers some different hurt. That's very helpful. And this body isn't really part of that. But what you're saying is this definition, if it has a precedent by this body giving a variance, it could trigger some other stuff. That's really helpful. I wasn't understanding that in the first realm. So that seems like where this real sticking point is if this language is used, you're concerned about other codes. I do think that's not necessarily this board's jurisdiction, and it is a little tricky. I do think that, tell me about the conversations you've already had with staff about this specific issue, or is this the first time you're bringing this to anyone's
Oh,
attention?
no, I wrote an extensive memo to Mr. Palmquist and Attorney Ashley regarding what the various definitions are. It's about a 2 to 3 page memo that I sent to them, Mr. Singletary as well about what exactly is considered a group home. And the big concern is, A, how the state could step in and regulate it, but also the fact that this is going to have a serious implication for other recovery homes, because then the city could come in and go
I've heard
ahead
that.
and do
Yep.
that.
I appreciate that, and I
Yeah.
think that
And I
that's
think-
I think where we're having some misconnect is
Okay.
what this board is here for
Okay.
and the concerns you're having, which I don't mean to quiet them. I'm
Sure.
really trying to sift through, because this is complicated
I appreciate
and
your
it's complex
comments.
for all of us. There is a pause that I kind of want to reflect back to the team. Let's say the code did say transitional home. Let's just pretend the word is wrong. Your jurisdiction is to consider use in an RM8. I haven't heard any of that deliberation, so I'm kind of curious if some of that deliberation would come out, because before there's a continuation or a variance, at the end of the day, what you all would have to say is around the land use of a bunch of people living in a place that currently is very much out of what our code says. So whether it's transitional, whether there's food regulation from the state, we care about RM8 means X, and our staff's professional recommendation is that y'all are out of compliance with that. So I don't know, the reason I ask for y'all's input on that, or to hear what you think, is that might inform where you want to go. If you're going to deny this, period, the end, then it's over, and that's one thing. But I don't know, I just feel like there's two conversations happening. Y'all aren't
Well-
privy to one.
Well, we haven't had a chance to have the full hearing because the applicant came up and is
Right.
asking for removal. So, I mean, it's hard to say right now if we would approve or deny this special use permit. But I wanted to ask Mr. Edgerton, if the definition, our definition, group home,
Has no controlling authority on a state agency.
correct,
Nor-
right? So
nor-
like, no one from the state could come in and say, because of our definition, group home, they can apply their definition of group home.
No, that's not how it works. It's truly the inverse. If the state mandates a definition and we have something that's inconsistent and it clearly applies in the context of zoning, then we get trumped. But we do not have the ability as one municipality in the state of North Carolina to dictate, because of a definition in our zoning code and how it's applied, what an administrative agency must do. That does not happen.
So do you understand what they're saying there? Is that the concern that there be a precedent set here at this commission with this word could trigger regulatory action from the state?
Oh, absolutely, because what will
No,
happen?
I'm sorry. That is incorrect, is what we're hearing right now, is that will not happen.
No,
That any
I
state
think-
laws, definitions will supersede anything that
No,
happens here.
I think what the problem is, if it's defined as a group home, it opens the door for the state to come in and say, we want to further regulate what you're doing. And that would be disastrous. It will totally, I mean, right now, there's 12 residents of the house. And under any definition of a group home, you'll never see it more than 8. So that is a serious issue. But it also opens the Pandora's box for there's over 20 Oxford houses in Asheville, and that provide transitional living. And it provides an opportunity for the city to come in and say, we're going to make you a group home
Could you
and
show me
affect
some
those houses.
precedents? Like,
Pardon?
give me an example. You've been citing some information. Can you show me some precedents where a local zoning decision triggered state regulatory action from a different jurisdiction? My legal counsel is telling me that is inaccurate. So I think this board has to sort through, if you want to delay so you can digest this really detailed, full conversation, or if you want to take legal counsel's advice or the gentleman's advice here.
The problem is that other municipalities have a very different definition of a group home. Like, for example, I looked at Charlotte. Charlotte has a definition of a group home. Clearly, a facility like this would not qualify. Part of the problem is the definition we have in Asheville is a one-off. It's a one-off definition. It doesn't make any sense. Whoever put this together, I hope it's not somebody in this room, it is not It's a one-off definition. It doesn't fit.
Would
that-
the applicant be willing to move forward with the application and then lobby for legislative change of the definition at a later date?
The only way we'd consider that, well, the problem with that is that would imply that we're accepting the definition that it is a group home. And part of the underlying problem is that there was never any notification that it was designated as a group home.
Which again, I'll remind you, is just outside of the purview of this board.
And I understand that. That's
Yep.
correct. And that's a good question. And I have to think
Yes, sir.
about that.
Can you say that again?
Go ahead. Carl.
So what we're trying to deliberate, and when I believe what staff has deemed as an outlet for this particular use, is within our own UDO, within Asheville's development code and ordinance, group home is defined as a residential home provided by an agency, organization, or individual for persons who need sheltered living conditions for rehabilitation. That is the definition in our UDO, and your council has advised that this is a one-off definition, that word means something different in other places.
Well, I'm thinking it would change the whole status of my organization as far as my home. The building that I live in couldn't operate with 4 residents in it. My residents work, they go back out in society, they get jobs, they pay a program fee. 8 residents couldn't pay the bills in that facility. So I would not last no matter what. If I could only shelter, which it is it's actually 2 homes in one.
Mm-hmm.
It was a nursing home, and then we turned it into transition recovery house. And so 8 residents could not operate that building.
So I might clarify a little bit. So where the 8 residents come into play, that's not a zoning consideration. So there are what applicant's speaking to is the state building code, which is a whole different issue that was also identified through this process. So that's a separate issue, regardless of the zoning or the classification. There are still going to be some building code issues that planning does not handle, P&Z does not handle, that might require things. It might not say you can't have more than 8 residents, but it might say if you have more than 8 residents, you might need sprinklers or certain firewalls or safety procedures, and that's going to be required regardless of
And that's completely out of our
the zoning
purview.
So that's not going to be remedied or changed by the definition of the use. So that's a whole separate issue that our building safety folks have been speaking to you all with too. So I think that's where the 8 number comes in. The zoning doesn't say how many residents you can have at a group home, so that wouldn't really affect this hearing or the zoning classification of the use. But whether we call it a group home or transition housing or anything else in between, there are still state mandated building code requirements that say if you have more than 8 people living in a structure, you have to have A, B, or C. And if you have A, B, and C, then you're okay. If you don't, then that's something that has to be remedied. That's separate from this process altogether.
So based on all this, I feel most comfortable hearing the application through and making a decision. If the applicant at the end of the hearing would like to express their intent or their request for continuation, they can make that. We can, as a board, decide to continue it or not, but it feels appropriate knowing the amount of time that's gone in from the staff perspective, from the applicant's perspective, to complete the hearing and, render a decision.
I would be okay with a continuance. I would only ask for 2 months because I'm going to be gone a couple of weeks in September on business. And I would like to have the opportunity, if you're willing to, is have a chance to come in and sit down and talk to you and maybe with Carl and see if we can come up with something that will work effectively, not just for this house, but for the whole issue of transitional living in the community.
A legislative decision on this would
Right.
take potentially 6 months.
Right, and I'm thinking that if we can
And
come
so
up with
a
something,
continuation here does not take care of your current use violation.
right,
That doesn't do anything.
That's why I
for
would
the-
propose solving this issue now and then you seeking legislative change separately.
While you're operating.
I mean, staff's happy to continue to speak with the applicant and try to find a way forward. This is, you know, I think this is still the best path forward. If it gets continued, we'd be glad to have dialogues with the applicant to explain our position and any other paths forward. If it gets continued, we'll keep having those conversations.
Will, how long has staff been in conversation with the applicant?
Since the notice violation was issued at the end of October, we've been working with
At
the
the end of
applicant.
October?
And
Last year.
Last year.
Last year.
Yeah.
So I'm not, what different would happen with more time for staff to have more conversation? Has there been new information presented during this proceeding?
I don't know.
Okay.
So yeah, I don't know where that would go necessarily, but we'd be glad to have that conversation. At some point, something's got to give. So the property, I mean, the root of the issue is that the only use that is allowed on that property is a single-family dwelling, and a single-family dwelling limits the number of unrelated people in a dwelling. So either that has to change, or they need to get approval in some way, shape, or form for the use that they're having at the property.
And when out of compliance, are there consequences issued? Have they been racking up fines between this October notice? Like, what happens between being notified of being out of compliance and a potential permit being issued?
So the current notice violation makes the owner-operator aware of the violation, and that as long as they're working in a constructive way to remediate that violation, such as having an open application through a special use permit, no fines or other
So there's
escalation of that
flexibility.
is happening in the meantime.
An unprecedented situation, though, would be where there's an application, the city holds off on issuing fines, and then simultaneously, the applicant who tendered that application says they don't want it to be granted. That would be a new situation that the city's not dealt with.
So what that implies that if the applicant pulls the proposal at this time, that could signal no longer participating in the special use permit seeking, which might then issue fines.
That might need to happen no matter what. If the indication is that, especially like if a just generic ambiguous resident submitted an application and we thought it was purely submitted for the purpose of delaying the accrual of fines, we would disregard that application. If we're dealing with a situation where there's an SUP application and the applicant is telling us they don't want it to be granted, it would be very hard to justify from a public policy standpoint holding off on accruing fines or issuing fines when that's the message that we're affirmatively receiving from the applicant.
Yeah, because when I first submitted the application, I was told that I had to I actually submitted a conditional zoning application. It was never a special use application. That came on down the line. When I asked about the conditional zoning, that's where we started getting things delayed because it wasn't conditional zoning, it was special use zoning. I know anything about special use zoning. I put in an application for conditional zoning.
And can I ask a question too? My understanding is that all conditional use permits need to come before city council, but a special use permit would stop here?
So that was an amendment that City Council adopted in January based on state statute guidance 160D update from a few years ago to change the authority for the final granting of a special use permit to Planning and Zoning Commission and not City Council. So it's correct, that's how it was handled in the past.
But if this were a CZ, it may go to council or may not.
If it was a conditional zoning, then City Council would have to approve it.
So what I want to share here is that conditional zonings, when it comes before city council, there's just a lot more community conversation about it. And I don't know if you're following the news and see the conversations we're having about the Ramada Inn, which is a vulnerable population. And so if it were to be a conditional use zoning process, there would be a significantly larger amount of eyes on it. of press on it. So I do think that although that was the original, you'd mentioned going in that direction, that as staff steered.
Well, that was the direction that I was veered into. I was told that I had to
Okay.
permit a conditional zoning application.
What I'll say is it sounds like the special use permit might be a quicker and.
Oh, yeah, absolutely. But I
less-
was just saying what I applied, my application was conditional zoning, and then it became special use on. So I don't know.
And I'm personally not hearing that the applicant is shying away from a public conversation around the importance of these facilities. In fact, I'm hearing the opposite, that, the applicant is using this as an opportunity to reinforce the importance in the community. So, that's what I've been hearing today. So just to kind of check in, we've contemplated various avenues. Is the applicant seeking a continuance? Would the applicant like this board to continue to evaluate the application before us for a special use permit?
I'd like to see a continuance so I get an opportunity to discuss this with the city planning office and, if necessary, with members of the city council even, because this is an important issue. And it's an important issue not only for Mr. Singletary's house, but for the city of Asheville.
And to be clear, if this board grants a continuance, it is for a request for a special use permit for a group home.
That's correct, because...
The applicant could then, in the intervening time, withdraw that application.
Exactly.
If you choose to.
Exactly.
But if it comes back here, we are evaluating
Yes, sir.
an application for a special
I
use permit
agree.
for a group home.
And I would ask you for at least a continuance for a couple of months, because I'm going to be gone so much of September. And I'd like to have an opportunity to get together with the city folks to discuss this matter.
Understanding that this has been kicked several agendas, and I know the city has an imperative to resolve this, would it be acceptable to continue one final time to November, given the new information and sort of public involvement of the challenges around the group home definition in the UDO? Is that something that staff would accept?
I don't personally have an issue with it, so I guess I would accept it. I don't.
So,
Let me add to Will's answer, with the understanding that we can only operate within the UDO, within the zoning definitions. That's been discussed extensively today, but that is important to know with any discussions we may have with the applicant.
I'd like to reiterate, I'm not in support of a continuation at this time.
That's fair.
so I also think, as the councilwoman said, we also haven't even gotten to the meat of the issue, which is even if definitions are changed, this is still not an RSA use. And I think this board, while I would like to see more conversation, and there is people who want this to be continued, we also have to consider the other neighbors and adjoining zoning people and property members beside it who have obviously somehow complained or see an issue here that caused this whole situation. I think we have to remember their point of view on the longer this is continued, the longer the issue they've identified hasn't been resolved.
Based on the number of people who are sworn in, it might be appropriate to ask whether any of the neighboring property owners here might assert that they have standing, and would, if so, they would be able to object to a motion to continue. And so that'd be worth knowing whether any of those people are asserting that they have standing to be heard in the course of this quasi-judicial hearing.
Thank you for that advice. I think that's valuable. So what maybe we entertain.
Typically, so Board of Adjustment here is way more quasi-judicial matters than you do. What we would typically do is just ask, is anybody who's here to provide feedback or participate in this matter asserting that they are a party with standing to participate? That has a legal connotation that's different than just giving a comment, but so the question is, does anybody believe that they are a party with standing to participate?
Thank you, Mr. Edgerton. What he said is, anyone here to provide witness testimony asserting that they have standing on this matter? So at this time, I think it would behoove us to open a public hearing or just reserve the right for these individuals to maintain their rights to assert standing on this matter.
Now, the applicant could stipulate that they agree that these people can be heard as parties with standing, but if not, you would need to ask how they would be able to assert that they have what's called special damages that would give them a right to participate in the proceeding. And so I think question one would be, is there any objection to hearing from these people and having them participate as parties?
Does the applicant object to these parties'
No.
claim to have standing? And do you understand
No,
what?
If somebody else wants to speak on the matter, we would be happy to entertain any other positions, but those people will be subject to examination by me if I have questions.
Does,
Fair enough?
Correct.
Or by city's council also.
If they're participating as a party, they would be able to say what their position is
Right.
on a motion. So if you're making a motion to
Right.
continue, that it's not
But-
really subject to cross-examination. If they're offering evidence, then you would be able to
Well,
cross-examine.
what I'm interested in is if they're making allegations about
Right.
something,
So right
I
now
should be
we're
able
on
to
the-
question what their basis of
That's
the
true.
allegation.
That's true, and you would.
Okay.
If we're just on the
That's fine.
procedural question
Yeah.
of
That's fine.
continuance, they would just be asked what their position is and whether
Sure.
they would oppose your request.
That's
for-
fine.
Yeah.
I agree with that. Okay.
so would anybody, I'm hearing that this is an open question, would anybody like to make a motion to continue this to date certain November?
The meeting in November, because it'll give me a time to get together with you, Will. Okay.
Do we know what that date is?
Well, also,
just-
well, but prior to the motion to continue, I think they have the opportunity to object to a motion to continue.
So what I'd like to do is see if even this board would entertain that motion. It may not have support. Regardless, we will certainly open the opportunity for people present to, provide whether whether they would like to enter into evidence and utilize their special status as having standing on this matter. So November
6?
Is there a motion to continue this item to date certain November 6th?
The day after election, are we all going to be awake?
I would support a move to continue.
So we have a
But I don't know if anyone else would.
motion. Do we have a second?
I'll second it.
So we have a motion, we have a second. Before we vote on this, Mr. Edgerton, could you advise on the appropriateness of allowing those who have identified themselves as wishing to seek standing, what would they provide right now?
So typically what would happen is just what's happened so far. Mr. Kaplan's made a motion to continue, and then you as the determining body would look to anybody who's opposed and say, are you, or who might be opposed and say, are you opposed? Do you have any opposition to this? What's your position on the motion that's been made? And then proceed with whatever your decision is.
Okay, thank you. Would those who have identified themselves as seeking standing on this matter approach the mic, identify who you are, and whether you would object to the motion to continue this to November 6th, or would like this board to continue with our deliberation today? And this, we're not talking about the substance of what testimony you might provide, really just the motion to continue this.
Okay. Can you hear me?
Yes, thank you.
I have very severe hearing loss from the military. And any real questions, say them really loud so my brother can answer them for me. I'm one of the owners of the property at 124 Rock Hill Road, which is right beside this piece of property.
Can you state your name?
Sir?
Your name?
Ledford, Ken.
Thank you.
And we've traveled up here from South Carolina for five times. In fact, some of you, I feel like I've bonded with you. And as far as I know, Mr. Singletary does not even own this property. He's not the owner. He rents it. And it is a group house. I've been in it. My brother's been in it. Another man's been in it. And they have their rooms. They have their family space in here, like, and there's no lights for security. They come and go as they please.
So might I just interject and ask, so would you object then to a continuance for 2 months, given that you have traveled all this way for the hearing today?
Well, we didn't know he was there. And we found out he didn't apply to the state to have a public meeting. So all of a sudden, one of our relatives called and said the guy stuck up a sign in his yard, in that yard today, that there would be a public hearing. Well, he's supposed to know everybody by mail. But when he first moved in, we got nothing. So we understand the statute of the state says you have a public meeting with the people close to the house, and if anybody, one person objects to it, it can't be opened. He never did that. Finally, when we had this meeting, 3 of us were there. We said, no, can't have this. Here, we want you to move.
So when we conduct the hearing under the 7 standards for a special use permit, you will be given an opportunity to provide witness testimony and enter evidence that would refute those standards. I think what we're trying to discern right now is the motion to continue, does it present a hardship to your ability to provide witness testimony as a person potentially withstanding that needs to be...
But out of the 7 up there, they violate 3 of them, big time.
And we will get to that.
Yeah.
We haven't even opened, that hearing. But I think I'm asking is, we either have an option to continue with the hearing today or in November. Would you object to a continuance that would come back in November? And
Yeah, we'll come back every time we'll be here in opposition. And
no
so
objection.
you do not object to a continuance, or you do object to a continuance to November?
continuance?
Yes. So continuance means we
Yes.
would pause the deliberation.
Sure.
The applicant would come back in November after hopefully resolving with staff.
Yeah. But this is a group house. This is no doubt. And,
Understood, and you'll be able to provide your testimony that would refute the applicant's.
And then we can tell you about all the break-ins we've had at our house since we started this.
Okay, but I'm specifically hearing no objection to coming back in 2 months.
We'll come back.
All right. Would anybody else like to speak to merely the delay in deliberation of this matter to November 6th?
My name is Andrei Shorgorowski. I'm living in 128 Rock Hill Road. I do have 6 children, 2 daughters, like 3 years old, twins. I bought 4 properties around this one, like many years ago. When I asked real estate what's going on with this building, she said it's like a single family home. I invest so much money over there. Even the city road I fixed, the bridge I fixed, because it's Edgewood Road, it's kind of private road. And I have to build like almost 7-foot wall, not wall, fence. Those guys, if number one is saying the public health or safety, it's not so safety. Police.
So, sorry if I could interject. Thank you for coming and speaking, and we will give you an opportunity to address the 7 standards once we are even in that part of the discussion. Do you object to this being delayed an additional 2 months and coming back? You do object to that?
Yes, I do.
Okay. Thank you. We will invite you back to speak to the 7 standards once we have had an opportunity to vote on the motion to continue. So, sorry, did you have?
No, I'm sorry.
So we had a motion, we had a second. We have heard from people asserting their right to standing. Do we need to let the applicant respond to their standing at this time, or do we vote on the motion on the table?
No, they said they don't have any objection. They waive any dispute as to standing, but they've only given their position on the motion. So if you think you want to hear something more from the applicant on their response to the motion, or if you're ready to vote, you can also just vote.
Hearing that we do have one objection to a motion to continue, I'm inclined to proceed today, but I'd love to hear a vote on the matter. So we have a motion and a second to continue this to date certain, November 6th. I'll ask all those in favor, please say aye.
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 Any opposed? Nay.
Nay.
So the motion fails. We will proceed with the hearing on this matter, which is, as a reminder, a request for a special use permit for a group home. So at this time, I guess we can proceed with the applicant's response to how this application for a special use permit addresses the 7 special use standards. Would that be appropriate?
Yep, they would be able to present their case as to why they think they meet the requirements for a SUP.
And then upon conclusion of that, our witnesses who have come here today will have an opportunity to provide refuting testimony. Would the applicant like to present a case on how the application meets the special use standards?
Well, if going by the 7 steps, like I said, I'm not familiar with this whole process. I don't think I'll get a fair trial anyway with it. But I'm just telling you that I do provide help for this city by taking people off the streets. We're bringing down crime. Everybody is going to have their own special opinion about recovery. So it really doesn't matter. A developer came in, we were fine, he started developing around us, then things changed for us. There's no evidence that anybody left my property, went to his property, and broke into any property. If you know where 130 Rock Hill Road is a very busy road, people walk up and down that road all the time. They catch the bus on that road all the time. And I feel that we're just being singled out because they know that they can. And maybe I don't have a stand for this, because like I said, I've never been through this process before. But I've been helping people since I'm a recovering addict who was in active addiction for 30 years, and somebody helped me. So I devoted my life to give back to my community and help someone else. And that's all I'm trying to do. I'm not trying to cause any problems for the city. I'm not trying to cause any problems for the neighbors. It's about money and cents to them. It's about saving people's lives to me. So, I don't know what I can say to change anything. What's going to happen is what's going to happen today, but I will not stop what I'm doing just because of one thing. I will continue the process that I have and where I'm going. I have opened up other facilities from my hometown because I wanted to give back to them that was so freely given to me. And like I said, I serve Operational Gateway, I serve Buncombe County Reentry Program, I serve Sunrise, I serve United Way of Rutherford. I house all their people. And it'll be a great loss to them. I have supportive letters of all these people have wrote for me to represent to you. But like I said, I don't know how this whole process worked. I know it started over one person complaining that his property wasn't sold because he felt like it was us. We were the reason why his property couldn't be sold. So that's how he went to the city, complained, and that's how we're here, because of one man and his complaint. But we haven't looked at the bigger picture of the people's life that we are saving. But it's always people invest in land and building, but they don't invest in people. I invest in people. And that's what I do, and that's what I continue to do. So I don't know, like I said, I don't know what you want me to say or how I can change your decision. I feel like it may be some biases here, and that's just the way I feel. But I've been doing this for a long time, and I know that it works. And if you take this away, then you take it away from the city.
If your special use permit is granted, it would not be taken away.
No, like I said, I would do whatever it takes because it's not about me, it's about the people that I serve. So I would try to apply, I don't want to do anything wrong. I'm not here because I'm trying to do something wrong. I'm here to try to find a solution. Because that's what I do. I find a solution, not only for myself, but for other people too. So if that will help me, then hey, I'm all for it. You know, I'm just not gonna give up and, you know, and run and hide like they want me to. Because I know that I'm doing something good. And it's not about money for me. It's about saving people's lives.
Thank you, Mr. Singletary. To directly address the allusion to prospective bias on the commission, I'll just remind the commissioners that in voting on this item, we are required by statute to not have a fixed opinion, not susceptible to change. So that is an imperative that we all take when we vote on this matter. But I appreciate your recognition of the importance of being unbiased in our decision making. I do have a question, Mr. Singletary, for you on item number 3. I've asked staff about this and would like some clarification from you in your response directly on the special use standard that the proposed use or development of the land will not substantially injure the value of adjoining or abutting property. In your response, you have claimed that this property will help neighboring property values. Could you expand on that, the justification or the evidence that you're providing that would support that?
I don't know. I just know that, you know, I had a neighborhood meeting. I sent out letters like Will asked me to. I had a neighborhood meeting, and I had other neighbors there as well as them who supporting what we do. So it's not the whole neighborhood that feels that we may bring down the value of their line. It's just certain people. You know, the property, I think, is valued, the value of the property I'm on now is like almost $500,000. So, I mean, you know, I don't see anything else around me that subjective that will bring the value of their property down. So
Understood.
if I'm answering the question right, I'm just asking.
Yeah. So under the special use standards, the burden is really on the applicant to provide the justification and the evidence that they meet all of these 7 standards. So that was the nature of my question.
Yes.
And I appreciate your response. Any other questions for Mr. Singletary?
Yes, I had a question. So for the SUP, for the special use permit, you're looking for a technical modification for the parking in the rear of the building.
Number of spaces in the front of the building.
Number of spaces in the front of the building.
Correct, and the
Okay.
number of front entrances too.
Those two, correct. Do you believe that it is a burden to topographically the way the site lays out to be able to put parking in the rear of the building?
Do I think it would be a burden?
Topographically, yes.
I mean, it would take away from the, you know, the property as far as to live, you know, where the people can socialize at, because we have the parking in the front. I mean, you know, and see, that's another thing. Staff, we have managers there 24/7. So very seldom there's more than 3 cars there a year because the bus line's in front of the house. So people focus more on riding the bus than they do buying cars. So I don't see where it was a problem, but the answer that I don't think it would be doable for us to put parking lot in the back. I mean, we probably could, but I don't see where it's a problem if we have to.
Okay.
So it would take away from what is currently social gathering space in the backyard?
Yes.
Okay. Any other questions?
And then I just wanted to comment, Chair Barton, you said it is on the burden is on the applicant for evidence. Mr. Edgerton, is that correct? Is it something about a scintilla of?
Yeah, there needs to be evidence as to each of the 7 issues presented by the applicant before this board can grant it. The burden is on the applicant to provide at least testimony as to why you think those 7 conditions are met.
They did submit a written.
Is the written response sufficient?
Yeah, it would be even better if it was somehow incorporated by reference. Like if we had testimony today saying that everything I said there is still true and I still believe that, that would allow it to be more properly in evidence before you all.
So, Mr. Singletary, the written responses that were prepared for this application in response to these 7 standards, do you stand by the accuracy of those statements and the evidence presented there?
Yes.
Okay. Any other questions from commission members before we seek witness testimony? Great, thank you, Mr. Singletary. I'd now like to open up the public hearing to our sworn witnesses who have appeared today. If you would please approach the mic, state your name, and as for quasi-judicial, do the time limits apply or?
No.
Okay, so.
The only caveat that I should add is that you have discretion on when something's becoming cumulative or is not relevant. You can cut the testimony off at that point.
Great, appreciate it, thank you. Please state your name into the microphone, and I remind you to present factual testimony that adheres to the standards that are up on the screen and how you as a witness are providing testimony that this application does or does not meet these standards.
Okay, my name is Lee Ledford, and my brother and I own the property at 124, which is just to the west of the home. And we found out that this was in operation when we had an offer on our property that we accepted. And in the 11th hour, the buyer backed out because there were sex offenders living next door. So we've had several other offers that we've declined because they're offering us below what we would consider a fair market value for the property. We had a second offer that we accepted. They backed out when they found out about the house next door. I've had the police over there 3 times. There have been 2 break-ins. I can't define who did it, but I will say that we never had this difficulty before the police was there. One fellow was ejected from the house, and he moved up and set up an encampment on our property. And I had to come from Simpsonville because the Asheville Police Department would not eject him from our property without me being there. So I had to come up, and he had moved furniture from my patio area down to his campsite. And when we walked up on him, he had a fire burning on our property. And the policeman put it out with a fire extinguisher, and I told the guy, I said, you got to go. I said, I empathize with your predicament. I said, but if I let you stay here, the next thing you know, I'm going to have 50 or 100 people staying here. I just can't do that. I have a responsibility to my property. And we have it on the market, and I don't think that a homeless encampment on the property would enhance its value. And I do think that what Mr. Singletary is doing is noble. And all we're really doing is asking him to move, because we feel like it's impacting our property value. So I guess that's about it.
Thank you for that. I think I heard a couple of things in your remarks, specifically that you do not believe that the application meets standard number 3.
Correct.
With regards to property value. I also, without putting words in your mouth about the fire situation, heard something that could speak to standard number 1, health and safety.
Well, there's another incident that I wanted to explain to you. The last time I cut the grass there, my wife and I had found the house open and broken into. And I've gotten to where I come up from Simpsonville armed, and I go in the house armed because I don't know what I'm going to meet. And I went in the house and announced, if there's somebody in here, you need to present yourself or I'll open fire, because I don't know what their intent is. And if they're down in my house, and I've gone through the house and run 6-inch screws into all the doors and windows to keep people from breaking in. So when we were finished cutting the grass and we were up on the landing at the front door, a couple of fellows had walked up the street because we called the police to come over. There were two cruisers sitting in the driveway. These two fellows walked up the street, and then they came back down later after we were finished, and they start yelling at us about cutting the grass. And so I decided, they walked on down, and we have what's left of a hemlock hedge there. The adelgids are killing it, so you can see through it. So I watched them go on down the street, and I walked out to the end of the driveway. They turned in at 1:30, and I went on down to the bottom of the property, and they went right into the house. So I considered it harassment is what they were doing while we were there trying to, maintain the property. I try to keep it up. So I guess that's the last thing that I have that happened.
Thank you for your testimony. Specifically regarding the allegations under standard number 3, I guess I'd like to seek city legal guidance on, do we need any this is sort of anecdotal witness testimony. Do we need anything entered into evidence that would corroborate?
No, this you can take and value any testimony however you give however much weight to it as you think is appropriate based on whatever corroborating evidence you may hear. Also add that the applicant has the right to ask any questions. So if they think that there's something wrong, they can ask questions to poke holes in that or examine what they've testified to further.
Great, thank you. Would the applicant like to ask questions of this witness? Please approach the mic.
I would like to ask some questions because there's a few things I'm not clear on. Sir,
Can you please speak into the mic?
yeah. You're talking about these various incidents. Can you give me a specific date of these incidents?
I can if I do some research.
But right now, today, you don't have it, correct?
That's correct.
Okay. At any time regarding any of these alleged incidents, and I say alleged because I have my doubts, and in any of these alleged incidents, did you make any attempt to contact and talk to Mr. Singletary about it?
I didn't even know Mr. Singletary was there when the first things happened.
Did you know, you knew that it was you knew it was a transition living house, though, correct?
Not at first.
Okay, what did you think it was?
I had no idea. I'm on my own business. So I don't go around asking the neighbors what they're doing at their house.
Okay, but you're concerned about these people that you think came from 130 Rock Hill Road.
I know one of them did. He was camped out on my property, and that's where he told me he came
And
from.
when was this? Was it in the last 6 months, the last year, the last
It was
2 years?
last spring.
Last spring being spring of 2024.
And I'm a scoutmaster at Troop 700 down in Simpsonville. One of my assistant scoutmasters was with me when we came up and evicted him from the property.
And he was on your property?
Absolutely.
And you knew he was from 130 Rock Hill?
Absolutely. That's what he said.
That's, yeah.
He is true. The individual did leave my facility and went to that property, which the record would show that I called the police on him over 3 or 4 times to have him removed from that property when he went over there. So like you said, when they came there, I could not remove him because he was on someone else's property. But I called the police more than 3 times to have him removed. I don't believe any of the guys in my house came up to his property because I preach to them the importance of being good neighbors and not getting involved with neighborhood. So I'm sure that wasn't from my house because there's a lot of roads that goes down there once you walk past that street. And plus we have plenty of people walk up and down that street every day catching that bus. So I have no control over what they do. But I do have control on what happens on my property. And I will say that incident, he is true that he moved onto his property, and I notified the police 3 times to try to have him removed. So once they leave my house, I really don't have any control over them anymore. I know that I can say, well, I don't have the evidence to prove it as well as he does it, that my guys will not go up there and break into his house. That house, it looks abandoned, it's weeded up, doesn't look like nobody lived there, but my guys will not go up to that house. I know that for a fact.
Thank you for that, Mr. Singletary. To our witness in I apologize, can you remind me your name?
Lee Ledford.
Mr. Leffert, do you have any evidence you'd like to present that would demonstrate a higher instance of crime in this particular location because of this facility compared against, the city at large or the neighborhood at large?
I don't have the police reports with me. The incident with the fellows yelling at us while they were working in the yard, that happened about 5 weeks ago. And they went straight down there, turned in, and went inside.
Thank you. If any other questions, or can we proceed with our next witness? All right, thank you.
Thank you for
Mr.
your
Leffert.
time.
Would our next, please state your name.
Andre. Sorry, I didn't finish. I do have like a house for sale. It's 27 Edgewood Road South. It's right next to that one. The house is for sale for over 160 days. It's perfect. I have like over a couple thousand people to see online the house. Over 100 showings. And 95% of the people complain sex offenders next door. I try to put that house for sale, for rent, and same problem of sex offenders. And how I say, I build a fence because the back porch and my front porch, it's only 20 feet. I do have 2 daughters. Some guy smoking marijuana. I told those people, we don't have video cameras to see what's going on around. And I show him some pictures, which that guys drink whiskey or beers and throw out those bottoms in my property. And that's why Section 3, it's develop the property, and Section 1, it's the public health or safety. And I'm not feel so safe with those people around my properties. Thank you for us.
Thank you. Thank you. I do have one question for you. If you could come back. Yep. You may ask questions. If I could ask one just before.
The question I have is talking about people that came to your house on your porch. Am I correct? When? When did this occur?
I do have some pictures, which could be date. It's an iPhone, and I show him the owner, which is running this business, like a bunch of bars, which also it's pictures. And also, like those guys, he say it's behind. It's not Rock Hill Road. It's behind the house. And so many guys, like sometime I'm working around the house, and he's coming and, hey, dude, can I do some work for you? I need like $10. I say, hey, step up. That's why I build a fence, because it's not safe for those 3-year-old daughters playing around the house.
To be clear, is your property adjoining or abutting?
Yes, three properties, 3 single properties joining to this property.
Would the applicant like to?
Mr. Singletary, you heard this testimony.
Yeah, so when we had,
address this if possible?
yeah, so when we had our neighborhood meeting, and like I said, it was several people from the neighborhood. I know he's been there. I was there before he got there. He built some houses behind me. He renovated some houses across the street. Then he moved from there on the other side of the street. And then he built, and I mean, he's never been a friendly neighbor to us anyway. So he's never been very supportive of what we do anyway. Like I said, people judge us all the time. When he dug his road out, of course, over there, where people do go over there, not my people, but when you cut through their yard and you make a road and there's beer bottles and wine, we get accused for that too. Some of them look like they're 200 years old. We still get accused of them too. So, I mean, I'm not gonna say that things haven't happened there, because it's a halfway house, it's a transitional house. But I'm saying we have not broken into anybody's houses. We have not approached or tried to harm anybody intentionally since we've been there. And I'm not gonna say that things don't happen there, because they do. But we do not affect the neighborhood. It's about building, it's about developing land, and it's about making money. And it's about getting us out of the neighborhood so they can continue that process. That's the only fight they got. Other than that, they don't have a fight with me. It's about developing their land for profit and getting us out of the neighborhood. That's what it's all about.
But I appreciate that, Mr. Singletary, and the reason that we're focusing on this is that there is a standard that we're required to evaluate the application under, which is whether or not the application will substantially injure the value of adjoining or abutting property. So that is why this is relevant, and that's why we're hearing out the witnesses.
I'm sorry, sir. Your 3 lots are to the north, is that correct? To the north and then to the east?
128 Rock Hill Road, 44 Edgewood Road, 999 Edgewood Road South, and 44 Edgewood Road South.
Yeah, okay. And access to the property that seems to be landlocked?
Yes.
Where is access to, how do you get to that property?
128 Rock Hill, it's right behind the 130 Rock Hill Road. It's side by side, but the building is behind his building.
Right, your building is behind his building,
Yes.
and the gravel road runs next to the building?
Yes.
Okay. Is there a ingress and egress easement?
Yes.
I'm just not noticing it on the plat. That's why I'm asking.
To be understand right, I'm not against, I'm supporting like Army, all rehabs. We are with our church helping I'm not against these houses. So many people, they are so nice over there. It's few guys which creating trouble, and they are know that. And he's saying, I saw and I took pictures how we are, after drinking, trying bottles on my property. And it's not from 5 years, it's few years. And I bought those property, how I say, was nothing over there. Even this building wasn't fixed to somebody to live over there. And I'm not against those kind of houses, we are helping those people. But I'm against like, I don't know how to say, my family, it's my family and safety, it's very important, with sex offenders and people from that yard to come on my property and ask for, hey, can I do something for $10, That's why I built that fence, and I show him some pictures.
To be clear, a sex offender could take up residence in a detached
yeah.
single-family home.
I was just going to make the same point.
So I think we need to be careful that is the criteria being used to say that this application is injuring the value of the property, when in reality, if you were next to a detached single-family home, you would have no control over who purchases and occupies that home. So what I would like to hear is specific evidence that speaks to why this application and why this specific use directly injures the value of adjoining and abutting property. Generally we would have some expert witness testimony from the applicant that would corroborate, and then witnesses could decide whether to refute or raise objection to that. I don't know that we can certainly entertain anecdote, but
Well, the same rule we discussed earlier, which is that the applicant can testify to the value of their own property, that applies to the people who own the properties immediately around it. So if you're trying to gauge the impact on property values, you can hear from each of these individuals on their own subjective impressions. But yeah, it's not the same thing as having an expert come in, but if it's just several subjective impressions, you've got those collected before you, and you have to make a judgment call based on it.
thank you.
Thank you.
I appreciate your testimony.
I just want to add that, I think the anecdotal evidence is fairly irrelevant, because at no point did any of these people ever say, well, maybe there's a problem, I should talk to the property owner. I don't know about you folks, but if I have a problem with an adjoining owner about something, I'm going to go over and knock on the door, ring the doorbell, and say, there is, I have an issue about your big tree, your whatever it is.
Understood, and we're not really here.
And I think you have to take this testimony for what it's worth, which isn't a heck of a lot.
I understand. We're not really here to adjudicate that, but I believe we have one final witness who would like to testify.
Yeah.
Because people have come in. I'm sure there's other witnesses too.
Okay. Yeah, thank you. Please state your name and.
Ken Ledford. I'm one of the owners of 124 Rock Hill Road. And what these folks are telling you. We didn't have any of all this stuff until these folks moved in. We started seeing a little bit of garbage, and then it increased, empty liquor bottles, used needles and syringes, used condoms, clothes, all on this. It's on the low side of our property. And I can't even walk my grandkids around their great-grandfather's property. This property's been our family since the 30s. And now, my brother and I live in South Carolina, and that's why we put it up for sale. And nobody had broken in this house until about 4 or 5 months ago when we started all this stuff. And we were there in that house, and one of the residents, that I told him he could not speak because it was between the landowners and Mr. Singletary. Our meeting was, and he was there, and I thought he was going to hit me when he left the room. He was so angry. I mean, total anger management. And there, we did not see any security lights outside. These guys were coming in and out the whole meeting time. So he has no control over these people. And people do walk up and down Rock Hill Road. It's not many. You take your life in your own hands when you walk up and down Rock Hill Road now. Because at peak times, from the red light at Hendersonville Road to the red light on Sweeten Creek Road, it's bumper to bumper all the way. And other times when they come across the hill from Hendersonville Road down to Rock Hill, it's like a racetrack. So people don't walk on that road much. I've seen 2 people the last 6 times I've been up here on that road. So it's dangerous. And then finding all this stuff on the property, we're afraid to come in the house up there without a pistol. You don't know if anybody's going to be there or not. It's just terrible. And I don't think, and as I say, 3 rules up there: endangering the public, making our land values go down, and it's not about money. It's about safety. It's about keeping Buena Vista like it was. It's a single dwelling family area. It's not multi. And it's just a terrible situation. And I don't think this is the only place that Mr. Sinclair has his fingers in Buncombe County either. So it's not about closing him down. He could move these people into his other houses. So, thank you.
Thank you. If you could stay up for one moment. I'd like to just provide the applicant the opportunity if you seek to ask any questions.
Can you give me specific dates of some of these incidents?
No, can you give me specific dates?
No, you're the one who's making the complaint, sir, not me.
That's right.
All right, and so I'm asking you if you can give me yes or no. Can you give me specific dates?
No.
Okay, thank you. His testimony, to my opinion, is so irrelevant, I'm not having any further questions.
Can I say something?
Go ahead.
So, you said these incidents happened like in the last 4 or 5
Mr.
months?
Secretary, I've talked to you before.
Yeah. No, you spoke with me at the
All
meeting.
you do is throw smoke and lie to us. That's it.
Sorry, if we could,
You don't
Sir, I
have
have
any
never
security
spoken to you.
lights.
Excuse me.
No control over these people.
Sir, I have
None.
not spoken
I have
you
nothing to
since
say to him.
the Neighborhood meeting.
so
That's the way.
if I could just interject, you're here to provide witness testimony. You have
Yes.
provided that witness testimony. The applicant has an opportunity to question, and
But
the applicant is
I didn't interrupt
exercising.
him. I didn't come up here.
I
run up
understand.
here, jump up here like a jackrabbit and start throwing out.
We'll
blah,
make
blah,
sure
blah,
that, we'll make sure that people remain, within the protocol of this hearing, but the applicant has an opportunity to ask questions if they desire. Mr. Singletary, do you desire to ask any questions clarifying?
Well, only thing I was asking, I've been there for 7 years. He's given me 3 incidents in 7 years that's happened there on his property. And they say these incidents didn't occur until after the land developers pulled out on buying this property.
No, that's not what I said.
The whole case came up because landowners pulled out on this property. Nothing was never said to me or related to the police about my facility until the land developers pulled out on this property.
That's not so. It was said to him before we ever had the first contract.
So, Mr. Chair, there's a key distinction here between asking questions, which is what cross-examine is, and making an argument about it, which is what your closing argument will be. And so if there's not a question being asked, that's not the proper function of cross-examination.
Thank you, Mr. Edgerton.
So that's not so.
I believe the applicant has no questions for your testimony, so we'll,
Okay.
we
finished?
accept your
Thank you,
testimony
guys.
today. Thank
I
you.
want to thank you for seeing us up here 5 times, 6 times in a row. I appreciate your service very much because I'm a commissioner for Greater Greenville Sanitation Commission in Greenville. We're the largest trash company in the state of South Carolina that's government-run. And I know you put a lot of time in that, and I appreciate y'all being here.
Thank you.
And thank you.
Yeah. So there have been some additional people who've joined our meeting while this item has been in progress. Has anybody that has come in wish to identify themselves as a witness on this item before us? We're on the quasi-judicial public hearing for a special use permit. If so, I'd need to swear you in. So is anybody else here to provide witness testimony? Seeing none, I'll now provide the applicant an opportunity for their closing remarks, followed by any further questions from the board as we deliberate. We don't have any specific questions, just an opportunity for final comments.
I've said all that.
Okay. Thank you.
Technically, anybody who has standing could also, but
Would anybody who has standing that has not been contested by the applicant wish to make any further remarks at this time? Seeing none, questions, comments from the board before we entertain a motion to approve or deny?
Well, I mean, the applicant previously stated they didn't want a special use permit.
So in proceeding with the hearing, are we doing so against the applicant's wishes? Is that the question?
Yeah, so I mean, if we approve it, are we going against the applicant's wishes? I'm a little confused in this scenario.
yeah, the point of confusion is probably stemming from the fact that the applicant always has a unilateral right to dismiss their application. There's no obligation for them to be here at all. They can control that. And so there's a bit of a weird disconnect happening where they're saying, we don't want you to grant this, but we also don't want you to continue it, or we don't want you to rule on it, but we also want you to continue it. Those are disjointed thoughts. And so they've presented evidence. They still have the option, if they would like to withdraw and dismiss their application, but that's up to them.
So you're saying the applicant right now could withdraw their application?
Yeah, they could absolutely dismiss it. If they don't want a special use permit to issue for the property that is before you, that is, and always has been, up to them.
Which would then subject them to the zoning violation, which has been stayed while this matter has been contemplated by our board. Would the applicant like to speak to the desire to withdraw or proceed with a motion by this body?
I guess the best thing for me to do is to go with the application, special use application, because it's funny because I'm standing up here actually not knowing what I'm doing, because it doesn't make sense to me, and it doesn't appear to make sense to you, but I want to do what's right, and I just want to follow the guidelines and continue the process that I'm going. So I guess that's why I stand here.
Appreciate that, Mr. Singletary. So the applicant has expressed a desire for us to proceed and either make a motion to approve or deny. Before we entertain such a motion, are there any further comments, questions? I have some of my own, but would love to hear.
Yeah, so this question is really for Mr. Edgerton about the the burden of proof and how much weight we give to things. You know, it's to our discretion how much weight we give to, you know, the evidence that was presented before us.
Yes.
And given the fact that there was no expert testimony, you know, I recall Miss Ashley mentioning something about a scintilla of evidence in each of these 7. Is that correct? Is that what applies here, or?
So the standard is that if you have one party come forward and present evidence as to all 7 issues, that these are all met, and nobody says anything to the contrary, then it is very difficult for this board to
say no.
substitute its own judgment and say, against all the evidence we've heard, which was only on one side, we're going to find the opposite. But what you've heard is evidence on both sides,
Okay.
and now the exercise that you have to engage in is balance. Which one do you think is more likely than not? Do you think all 7 of these things are true based on the evidence you've heard? And that's up to you all to decide.
Thank you.
So I'll provide where I'm at. I'm very sympathetic to the witness testimony we've received. I know there's always frustration involved when there's a perception that a particular property is creating a nuisance within a residential neighborhood. That said, I have not heard any testimony or seen evidence that there are functions inherent with the group home use that are not inherent in any residential facility and any potential for you know, a bad neighbor or bad activity. And so it's hard for me to support a denial of this application merely on the grounds of what we've heard today. There certainly could be other factors that have created a softening of property values aside from the specific use and the specific group home as being described by our zoning ordinance. So that's kind of where I'm at, but I'd, you know, love to hear others' thoughts, or if there aren't any, I'd entertain either a motion to approve or deny this application.
I'll just say I think that was well said, and I agree. A lot of the evidence presented to counter the application for the group home didn't seem specific to the use that we're discussing. So I appreciate the way you said that, and yeah, feel similarly.
Is there a motion to approve or deny the application before us?
I have a motion. Based on the competent material and substantial evidence presented at this hearing, I move to approve the special use permit for New Hope, New Beginning Group Home at 130 Rock Hill Road because the proposal meets the 7 special use standards outlined in Section 716(2)(c) of the City of Asheville Unified Development Ordinance.
Do we have a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed?
Nay.
The motion passes 5-1. Thank you to the applicant. Thank you to the witnesses for appearing today. I apologize for the excruciatingly long hearing, but I think we got through it all together. With apologies to everyone who's showed up for the rest of the items, I would like us to take just a brief recess to take care of our basic needs. So could we get just have a brief recess until 5:40, a 7-minute recess? Is that too unconventional? All right, we'll resume at 5:40. Back to order at 5:42. Appreciate everybody allowing us that brief break. The next item on our agenda is a legislative public hearing. This is a request to amend the adopted urban village master plan for property located at 99999 Hill Street for the purposes of amending the site plan and proposed mix of land uses. The property's pins are identified on the agenda with potentially a couple of adjustments that will be made before heading to City Council. The property owners are Blue Ridge Views NC LLC, W. Carter, and William H. Kilgore heirs. Property contact is Mr. Chris Day, and the planner coordinating review is Will Palmquist. For this item, we're going to do things a little bit differently because of the length of this meeting. Some members of the public have shown up to participate in public comment. We want to honor their time commitment today and open up the public hearing in advance of the applicant and staff presentations. The applicant has no objection, so at 5:43, I will open up public comment on this item. Members of the public who are here to speak are reminded they have 3 minutes of speaking as an individual or 10 minutes if representing a large group of minimum of 3. So please approach the mic, state your name, and thank you for coming.
Good afternoon. Thank you for allowing us this time. We're on a real tight schedule. My name is Sophie Dixon. I'm president of the Shiloh Community Association and also a member of the Legacy Neighborhood Coalition. And we are all working together because that's what we're trying to do, is try to keep us together and hang on to what two pieces are left of our communities. And in this case, Hill Street is part of that. That's in what was called Stumptown, where I was born and raised, and I was born 87 years ago in Stumptown. So I know all about Hill Street. I went to school there. And what we're trying to do is to make sure that there's something left, because everything's gone. When 240 came across there, it took all the houses and everything from across there. So we're asking, and I think there's been an email sent by Rashida Hall, who's part of her family still lives in the Stumptown area and Hill Street area, and she's asking for some consideration of whoever is taking over that property to redo it, to look at this and see what else you can do to help support the legacy of that community. So that's really why I'm here. I kind of got in on late, but we work together, and so we know what it's like to have everything just torn apart. And so what we're asking you to do is please take a look at those emails. They're very, very specific about what they're thinking. They're not trying to keep from having the project, as I understand it, but what they are trying to do is hang on to some of the legacy of that community. Thank you.
Thank you. Anyone else here to speak on this item?
Good evening. My name is Norma Baines. I'm the liaison for the Shiloh Community Association, and I just want to iterate what Sophie has just said. We're here in support of the legacy neighborhoods, and Stumptown is one of them. And I hope that you would consider all the things that the people have written in and they want to see put up. You know, so many of our historical buildings in Asheville have been torn down. So we need really to see some of our legacy around Asheville, you know, because we live here too. I was born and raised in Shiloh and lived there and moved away and came back. And hopefully we're trying to make sure that the legacy neighborhoods are recognized and they have their legacy in Asheville. Thank you.
Thank you.
Thank you. Anyone else wish to speak on this matter? All right, seeing none, I will close public comment at 5:47. I will reopen public comment after the staff and applicant presentations, but I appreciate you all coming out tonight.
Chair Barton, I guess I happened so quickly, going over this project, I failed to mention. We discussed this last month in the pre-meeting, that the company that I work for, Equinox, has done work on this project a while back. We surveyed the stream, we looked at the stream delineation, and we looked at greenway alignment. And then, we parted ways with the development team on a mutual basis. And I just kind of wanted to bring that up. I don't believe that there's any conflict of interest, but I wanted to bring it in front of the commission's attention.
Great, thank you, Mr. Cycle. I appreciate that disclosure for transparency. Do you feel like you can provide, sort of a neutral assessment on the deliberation and vote of this matter?
Yes.
And do you have a direct financial tie to the development plan that's before us?
No.
I would guess I would seek city guidance on whether this rises to
Those are the
conflict.
two questions, and no, I would not advise that this is a conflict of interest that would require recusal.
Great, appreciate that. And with that, accepting that, we'll move on.
Plug that TV back in, did it get unplugged? Sometimes it gets little things.
Good thing Jason's not recused because
We need him.
we need him.
Back in now, I don't know if you have to turn it back on.
Yeah, we got some movement. All right. Well, I got Chris here as tech support, so there he goes. Yeah, exactly. All right, thank you. Good afternoon, Commission. Will Palmquist with Planning and Urban Design. I'll be presenting this petition for an Urban Village Master Plan Amendment for a project known as Asheville Sanctuary. This is the project site located at Hill Street. There are 42 properties in total as part of this Urban Village Master Plan Amendment. They total approximately 10 acres. The site is currently vacant. I'll speak a little more about that in a moment. It's part of the former Hill Street neighborhood. You can see to the west Isaac Dixon Elementary School, and there are some streams that run through the property in this vegetated area that actually run through the site and kind of split it in half. There's also a Asheville Rides Transit Route N3 that is located along Hill Street as well. So the existing zoning, I'll speak a little more about urban village zoning and what it entails and the nature of this request that's before you this evening. The site is zoned urban village. There was a initial master plan adopted in 2007, and then it was amended in 2009. That project was known as Montfort Commons. You can see the geography of the project site in the red hatching and the zoning in the blue. So just, it's not super pertinent for the deliberation of this amendment, but just a note that some of the properties that were zoned urban village back in 2007 are no longer part of this master plan amendment, so you might see some discrepancies in there, but there are no properties being added to the urban village district. So none of the zoning's changing technically, so the existing zoning is going to stay consistent as urban village. The future land use of the properties is a combination of employment and anchor institution, as well as traditional neighborhood. On the north side of the project site, no change in that would be required. And just a little bit of history, heard from the public a little bit about their direct experiences with this based on information in the African American Heritage Resource Survey that was completed a couple of years ago about the Hill Street neighborhood. You can see the Sanborn map on the left. You can see Hill Street here, and then Haywood Street, which is now part of downtown, and then I-240, which was constructed through here, which caused the demolition and through urban renewal of all these homes, and also the homes on the north side of Hill Street. I don't know why they had to demolish those homes technically, since there's no highway through there, but that was all part of the same urban renewal projects. There are a few houses that are still intact in this area, but by and large, all these houses were removed as part of that urban renewal project. So What's basically before you today is an amendment to the previously approved Urban Village Master Plan. Back in 2007, the applicants for those properties requested rezoning to Urban Village. Urban Village requires a master plan be adopted as part of that zoning. This is not a conditional zoning or conditional zoning amendment, so there are no project conditions or, the level of conceptual plans that are submitted, they actually are more detailed than what is required technically, which is helpful to review the project, but it's not as detailed as a conditional zoning. There are no technical modifications being given or project conditions being adopted. Basically, what happens is the Urban Village District gets adopted with the master plan, and then the project comes back at level 2 type reviews that are reviewed by staff in phases as necessary. So it's a good way of having a conceptual plan approved and then having time for the applicant to work on the details and come forward with a more specific development proposal that's in line with the adopted master plan. So revisions, therefore, can be made by the Planning and Urban Design Director since some things get changed along the way as projects get more detailed. There are some limits to the extent that the Director of Planning and Urban Design can make changes, however, and this includes the 3 listed here, which are triggering this required amendment to the Urban Village Master Plan, and these include an increase in the overall development intensity, changing the proposed mix of uses by more than 25% in any given category. So you can see that between the previous approved master plan and this version, there's a relatively modest increase in residential uses, but a pretty significant change and decrease in commercial and office uses, which kind of makes sense given today's real estate market. But those are triggering the amendment, as well as increasing the maximum building height proposed, which is an increase from 4 stories of the previous iteration to 6 stories in this current iteration. The future level 2 reviews of the project would therefore then be required to meet all the requirements in the Urban Village District, as well as generally conform to the adopted master plan. So this is the master site plan. I have not inserted a lot of the renderings and other graphics. The applicant has a more graphic-rich presentation, so I'm going to defer more to them to talk a little bit more about the character and design, but this kind of gives you the overview of the uses and the scale of the buildings being proposed in this area. So you can see there are a total of 337 residential units proposed, about 20,000 square feet of commercial space, and a total of 859 parking spaces. There are a few different buildings here. I'll start with the first one that fronts along Hill Street, which is called the West Building. That would be proposed to have 147 units, 8,600 square feet of commercial. It's proposed to be 6 stories in height and has 2 levels of below-grade parking. The East Building, just to the east of West Building, is a little bit smaller. It has 86 units proposed, 12,000 square feet of commercial, similarly 6 stories in height, and has 1 level of below-grade parking as well. The Forest Building, which kind of looks like 2 buildings here, but actually has an underground parking structure that kind of ties it all together, is proposed to have 126 units. It would be 6 stories as well with those 2 levels of below-grade parking. And then to the north of the creek that separates the property or splits the property up a little bit are those buildings called Creek Buildings. And they would have 18 units total. They'd be 1 story in height and have a level of below-grade parking. Some other aspects of the site design I'll point out is the access to the site is proposed at 2 points at Hill Street. There is a new street proposed called New Barfield Avenue, which would kind of be more of a service type alley that would run on the side of the property. And then Michael Street, which is proposed to be relocated from its current location further up Hill Street and moved to this location. That'd be kind of the main entrance to this development. There's also, as you can kind of see from the property map on the earlier slides, a significant number of right-of-ways that would need to be closed. And that would be a separate process that the applicant would have to request those closures of the rights-of-ways that are still mapped as a legacy of the single-family properties that once existed. Obviously, these creek buildings would be accessed off of Gudger Street. Some other things to point out is that this site is kind of a location of a couple proposed greenways as part of the Greenway Master Plan. The Reed Creek Greenway and also the Montford Commons Greenway. The Reed Creek Greenway is a pretty significant greenway that's proposed that would run kind of from Merriman Avenue through the Tourism Authority's site, and then would find its way to this site. And the applicant and transportation staff have been in communication about how this project could at least allow for the siting of that greenway through the site, that it could potentially run through the site along the creek area, and then the ideal alignment is that it would run through the side of the property where there are landscape buffers required, which is allowed to have greenways running through that area. So that's something that's kind of still conceptual in a lot of different ways, but there's been conversations about this. So this site could allow for that to happen, and I think would also benefit from having a greenway connection run right through it for the users of the site. Other things to note is that there are no off-street parking requirements, so no off-street parking is required in the urban village district, but there are limits to the amount of off-street surface parking, and that no more than 50% of all parking spaces can be surface parking. So at least half of that has to be in a structured parking lot. In this case, the vast majority of the spaces are proposed to be in structured parking. So this project was reviewed by the Technical Review Committee at the July 1st meeting, where it was approved with conditions. The project would go forward to City Council for final consideration after Planning and Zoning Commission weighs in and gives your direction of it. So the future land use map, as I mentioned earlier, it's two different categories. The employment anchor institution is the majority of the site, on the southern part especially. This talks about envisioning more mixed use, multifamily, better integrate institutions with the surrounding community. It should include transit facilities with a strong multimodal access and connections to the region, and safe pedestrian routes throughout the centers. Traditional neighborhood, which is located at the northern part of the site, is often located nearby neighborhood centers that contain a mix of residential and small-scale commercial and office uses. The project supports a number of goals in the city's comprehensive plan, including encouraging responsible growth by providing infill development in targeted growth areas, increasing mixed-use development along transit corridors by encouraging large-scale land assemblages, and integrating these developments with the surrounding area, including the creation of walkable urban street grid patterns, and also increase and diversify the housing supply by increasing the rental housing supply. Staff recommends approval of this Urban Village Master Plan Amendment request. I'd be glad to answer any questions you might have. We also have the applicant here with us this evening to present more information and answer your questions as well.
Thank you, Mr. Palmquist. Any questions for staff?
So what we're approving is a master plan because it's not building specific and that can all change, correct?
The building specific that what?
Buildings can change?
They can change slightly, so it's kind of the massing and the overall uses, so they wouldn't be able to change the site plan significantly, like move the buildings all around or increase the heights or that kind of thing. But it's very conceptual in nature, so they'd be able to adjust them to some degree, but not so significantly that it was no longer generally in conformance with this master plan. So you're kind of seeing the site plans. The applicant has a lot of graphics there. I'm happy to share with you all. Are a little more detailed probably than maybe a conditional zoning would probably be a little more true to the site plans and the renderings where this is helpful to have an idea of what it could look like, but it would be able to shift a little bit more than a conditional zoning technically.
And building on that question, so the building approvals would happen as level 2 projects within TRC. Does that mean that the design review committee, this is outside of the perimeter where design review committee would
That's
weigh
correct,
in?
yeah. So the site's located outside of any kind of design overlay. It's not located in the CBD, so would not be reviewed by the DRC or by you all at any point in the future, as long as what they submitted in their next, in their level 2 reviews were in conformance with any adopted master plan and also met the criteria for amendments and weren't over 25% of the uses or any extra height or intensity of development.
Thank you.
And are the additions to the TRC included in this, what we're looking at currently?
Are the additions to the TRC?
Wasn't it with some requests?
Oh, yeah, the conditions of the approval. So that's encapsulated in the TRC staff report. So there are, like in any kind of technical review for a conceptual project, like a conditional zoning or urban village master plan, there are a lot of, I guess, T's to cross and I's to dot still. So those are kind of the conditions that the TRC says, well, we approve it conceptually, but they'll have to come back for a final review and they'll have to make sure they address all the technical details that are obviously not worked out at this stage of the project.
Such as traffic study.
Correct.
Will be required, but hasn't yet been reviewed.
Yep, that's
under the
one, for
TRC.
example, yes. And it is true, that's a good thing to point out that I meant to mention, is that a traffic impact analysis is specifically required for an urban village master plan project, regardless of any kind of criteria that would otherwise apply to most projects.
With this project's pretty prominent right on Hill Street. When you're going down 240, you're going to see it. Maybe not as much as the Hotel Indigo or something like that. But with this lying outside of the design review committee's overlay, have you or any other staff signaled concern that we're going to get an ugly building?
I have not signaled that, although I think no one wants an ugly building. But this is, I guess this is kind of where zoning leaves off and then design picks up. So a lot of times any project outside of the design review areas doesn't really, there's no, unless it's a specific form-based requirement, there's really no mechanism or purview to review the design or colors or that kind of thing of a building. So I guess that's always a concern. There are some requirements for things like the stepping back of the building at 4 stories, so it has to have some relief from the scale. There are requirements for windows and entrances and that sort of thing, but that's more about the composition of the building, less about materials and colors and detailing, and that's just something that the zoning would not address. So that would be at the behest of the applicant and their design team to create a building that
A project this size would have like an architect too, right?
Correct, yep.
Somebody who's been trained in that sort of thing?
That's correct, yeah.
Okay. And just making sure.
Yeah, no, it's a good point, and it's not a very confident answer, but that is the truth.
Okay. When I was reviewing the application and looking at reasons why an urban village would come back through for review, there's discussion about intensity of use.
Yep.
And within urban village, there's a lot of kind of verbiage in here where one residential unit shall be regarded as the equivalent of 200 square feet of commercial floor area, 1,000 square feet of office space shall be regarded as 350 square feet of commercial floor area. One residential unit shall be regarded as the equivalent of 500 square feet of office floor area. Are those, where do those calculations come from?
So I don't know exactly how that was determined. Kind of joke that like the section was written by a mathematician and not by a planner. So I don't know the exact comparisons that were made from that. But yeah, there is like a scale kind of worked out for equivalent, I guess, impacts of land uses. So my understanding is that you could take those equivalencies and add them together, and if the project changed certain ratios of uses, you could determine whether that was a change in the overall impact of the project outside of the 25%, shifting. So I don't understand. I don't know. I can't tell you where the origination of that equivalence or the equivalencies were created.
Okay. Is use like one of the primary concerns of form-based code and master planning in general?
It's a very important concern. It'd be more relevant to a master plan. It's less so in form-based zoning, though.
Okay. Awesome, thank you.
If I could, land the plane that Commissioner Wheatley is, circling. And I promise not to go down too far a bunny trail, but the thresholds that we currently have in place signal, equivalent intensity of use with 49 residential units and 100,000 square feet of commercial, office, industrial. So using the math in this section, a 100,000 square foot office building would be equivalent to 100 residential units, which is kind of an interesting anomaly that we set a threshold at 49. So I'd just like to point that out. We can put a pin in it. It's not really relevant to this conversation, but yeah, thank you for bringing that up, because I kind of looked through that section too and was like, this is an anomaly within the UDO.
Well, I mean, I think it speaks to an interesting concept that I think, as a community, we like organized, thoughtful, considerate design, and maybe we could consider that an incentive inside of urban village, and then outside of urban village, the disincentive would be to actually plan for less units. And so it is something to think about, not for this particular project, but I appreciate you landing the plane and not just letting everyone wonder what the heck I was insinuating.
Over my head too, so.
Appreciate you, Will.
Absolutely.
Any other questions for staff?
Mr. Palmquist, I got two questions. In regards to approving a master plan, I mean, I'm thinking of the Stumptown group and the Legacy group and some of their emails with requests in there. I mean, do we have the capability to add conditions on a project like this? I'm not proposing them at this moment. I'm just curious if that option is available.
So not on a project of this nature. Since it's not a conditional zoning, there's not a mechanism to have conditions. So even if the applicant technically said, well, I'd agree to this or I'd agree to that, there's no project conditions associated with it.
So it's a good faith effort. It's not like a written.
Yes, there could be some intentions and good faiths identified, but essentially it's approving the master plan, the massing, the uses, and then the zoning as written in the urban village, which is very specific as you try to sift through it all, is what controls the future iterations of the project.
Okay. And the second question I had was under consistency of the comp plan on the staff report, the proposed development is compatible with the future land use designations of employment / anchor institution. So anchor institution would be just like
could be things like a major employer or a hospital or
a Y or a church or
or a government center like here.
But at this point, like, we're not sure, like, there's not a anchor institution necessarily like in play on this one. I mean, it'd be nice to have one, but it's not like there's a commitment by anyone to.
No, this would be more of a mixed use residential commercial development. There's no other there's really no institution or other nonprofit or other entity that's going to be the center of this at all. So the future land use, I think the description fits fits what's being proposed. I think the name of it is a little misleading since there's not really an anchor institution. So not to my knowledge, is there any type of major anchoring institution being proposed as part of this?
At this point.
Mm-hmm.
Thank you.
Yep.
Shall we hear from the applicant?
I just wanted to verify there's no affordable housing associated with this amendment, correct?
Not identified in this application. Yep.
Thank you.
Would the applicant like to?
Yep. Yep, you got it. Oh, do you want yours or mine?
Which one's the CTC? That's fine. You can leave the CTC up. That's
Okay.
fine.
Either one.
Good evening. My name is Derek Allen. I'm with Allen, Stahl, and Kilborn. We've been working with the development team, who includes a local architect, Carlton Collins, as well as local engineers from Civil Design Concepts, their entire team, as well as our project development team. When this project first landed on our desk, and Chris Day and I were looking at it with the client and trying to figure out what to do with this old master plan from Montford Commons, we were trying to figure out what the zoning designation was. And in looking at that, we saw this UV. And so the first thing I did was call up Will, and I was like, what's UV? And he didn't know, I didn't know, but you can find those things in the development ordinance. We found that was urban village. And I was like, are there any other urban villages out there? And Will and I started looking at it, and it turns out there were three that were approved. There was this one that was approved. There was one that was approved that ended up being a project that you guys took a look at on Fairview Road. That was the old screen door property, and that one had been disassembled at one point. And there was Biltmore Park. Biltmore Park's the only one that was built, and so that was kind of the design of it, where you had different kinds of residential uses, commercial uses, office uses, entertainment uses on a large parcel that would be built over a long period of time, predictably in phases. So this thing was rezoned in 2008 to that urban village designation. It was amended through this exact same process that we're going through right now in 2009, so we did have some guide, because there weren't a whole lot of folks in the city that even knew what this was, and I'm not sure who all the city is still here now that was there 16 years ago when this thing first came through. When we were looking at this, we wanted to figure out the procedure was the first thing that we wanted to do. And so we did a lot of back and forth with City Legal, with Brad Branham, with Will Palmquist, with Chris Collins, going back and forth on how this thing works and looking at this ordinance and backfilling the amendment that already happened to figure out how the process goes through. We developed a memo that we worked and cleared through City Legal on how it goes. The big points that need to be understood are there are planning staff level changes that are allowed to a master plan, and that's what's here before is that there's a master plan. It's already out there. We could build it tomorrow, build it next week. It would go through level 2. Inside of that master plan, there's a unique amendment process that only applies to UV. Only UV, nothing else in the ordinance. And inside of that, there are sub-threshold level decisions that are changes to the master plan. Lots of it is, what does this look like? Where does this go? And those are at staff level. And those are where those things have been proceeding. That's primarily what you see in terms of those TRC comments. The threshold comments are things, big things. Are you adding property? Are you changing any particular use, commercial or office or residential, by more than 25%? Are you making it bigger? And those are the things that go to City Council for City Council's review and approval as part of the master plan. Will's staff report gets it all right, except I don't think that we're increasing the intensity. I think we are actually less intense now using that formula that Mr. Wheatley was talking about. And I'll get you the spreadsheet that we've been using. We do have a little spreadsheet. You put in this much office space and these many units, what's it do to the overall intensity? So I'll get that to you before we get to City Council. As we look at it, the way that City Council gets to review this project is that there are two things that go before City Council. One is the increase in height from 60 feet at the tallest under the approved master plan to 68 feet with some, it goes to 71 with some little architectural pieces, but that's what we're looking at for the height increase. And then for the changes in use, types of use, we are reducing significantly the office space, reducing a little bit less significantly the commercial retail space, and increasing substantially the residential space. We were answering that community call for more residential, and that's what's coming in this. In terms of some of the softer pieces, what we try to do is make this fit with how this entire development community over here has changed. There's a brand new school there. There's a Chamber of Commerce is now there. There are different people that are living downtown. Downtown's kind of come this way a little bit. And we have, I think, grown as a community. For us, once we figured out the process, we're like, this isn't a CZ at all. This thing is almost as of right. And at that point, this has been almost a year, at that point we said, all right, just because we can do this as of right doesn't mean that we need to go ahead and start charging the hill on this. Because this is a very unique property that has lots of potential interest groups in it that would want to be involved in the communications, involved in the programming, involved in the conversation. And so we made a list. And that list came out of the history of this property. Hill Street, Cherry Street was a historic black economic center. It was a residential center. It was distinct from Stumptown, but very close to it. Stumptown is also in this area. So we wanted to make sure that we were reaching out to folks that we're still associated with. So we did reach out to the Stumptown Fund. We reached out to the Community Land Trust and did that as part of the conversations. As we're looking through how the property was developed, we also looked at what happened after the economic downturn. Duke ends up with the property after taking it out of foreclosure, and Duke tried to put a substation there. If you remember that, if you had I had a kid there then, I've got a kid there now, it's a different kid, thank goodness. But back then, we were all fighting against Duke putting a substation there. So this is that same exact property. Here we are 15, 16 years later, and as a parent of a child that is at Isaac Dixon, the parents talk about the current uses on this property. We have spent this year over $60,000 in cleanup that the city actually made the developer do here because of unauthorized use, we'll call it. They had to remove last time they were out there, they removed 6 5-gallon buckets of used needles. That's something that's right beside a brand new school with elementary children. So safety, concern for the parents, those are things that we're trying to also pay attention to. Just going down the list and making these calls and talking to planning and staff as well as you folks here, the questions were, what have you done? What have you done on the reach out? And so I have a little list here of folks we've talked to. I mentioned the Historic Stumptown Neighborhood Association and the Asheville Buncombe Community Land Trust folks, Amy Worthen and Rashida Hall. I saw the emails that came in. The suggestions that were in those emails as well as that were mentioned tonight came directly from a conversation that Joe Lieberman on our team had with Amy and Rashida, and we'll continue to follow up on that programming. And we reached out to them as late as 2 days ago to talk about meeting after we get through this hearing. Buncombe County Commissioners, Al Whitesides, his family is from this area. Amanda Edwards, we reached out to city council members in advance of it going to, before it was even filed as an amendment. We reached out to the Christine Avery Learning Center folks, C.C. Weston and Deborah Bryant, which is housed in the Hill Street Baptist Church, which is right there adjacent to Isaac Dixon. We met with Daphne Jones at the Hill Street Baptist Church. We've met with Isaac Dixon Elementary folks, both in terms of the parents of the association as well as with the principal. Montford Neighborhood Association, the Greenway Commission, Dave Nutter, I've met with him numerous times on that connection. You won't see the piece that connects, little hashed piece there, but we've got a planned Greenway connection that gets you from the upper Montford area all the way down to the bottom side of Hill Street where you can take a sidewalk down to the Greenway on Riverside. We've reached out to J.D. Ellison Communications and NOR Collective. We reached out to the safety directors for the schools. We reached out to Asheville Chamber of Commerce, Kit Kramer and Zach Wallace, and then all of the neighbors that have either sent messages in or attended our neighborhood conference that we had. While we've done these things and done these reach outs, we've done them not because we had to, because it made sense. We didn't have to provide a neighbor notice meeting, but we did it because it's the right thing to do, one, and it felt like the right planning thing to do. We sent out 260 plus invitations. We had 8 follow-up communications with folks related to that. I mentioned the city council, but I didn't mention what your role is. While the city council gets to make those above threshold changes inside of this amendment process in the ordinance, it allows for city council to refer the matter back down to the Planning and Zoning Commission for advisory comments. In working with city legal and city planning, we decided that it would be a better idea to put it in front of you first, just assuming that city council would want to do that to save time and also to get as much input along the way as we possibly could. Same idea with having these neighbor meetings, same idea with reaching out to get those ideas and those comments and that discussion on the way up to the decision so we don't have to come back and do it later on. With that, I'd like to invite Chris Day up to go through some of the colorful presentation parts of this, where he'll walk through what's already approved, what was part of Markford Commons, and what we're proposing to change.
Thank you, Derek. Chris Day, Civil Design Concepts. Appreciate the opportunity to be here. Derek did a great job. This is my 19th year working in the city of Asheville, and I've never had a project that's followed this process, and glad to have Derek kind of helping steer the ship with this one. The only thing he got wrong, and all of that great stuff he talked about, and it was very small. So the property up there, as you see on the context map, it's about 10 acres in the shaded blue. That's where the development is proposed. The land also encompasses the kind of peninsula and sliver that's back behind Isaac Dixon. The only programming proposed there is some trail connectivity. So we're going to work with city staff on what that looks like. And want to acknowledge and appreciate, as Jason made reference earlier, his work, especially with the city and early on in this project with some of that. So thank you. The one thing that he had gotten wrong, the current use out there, our client, it was not 6 gallons of removal. It was 6 30-yard dumpsters of waste removal and 42 gallons of needles and drug paraphernalia that were removed from the site. So we're really excited about moving dirt soon and moving forward with a project out here and really changing what's happening out there today. Let me see. So this exhibit here on the left side, you see the approved master plan. As Derek made reference, this is actually the second approved master plan. So this one, the original one was in 07-08. This one was then revised to what you see on the left side of the screen in 09. And on the right side is what we've submitted and what we propose. So our client bought this land with this vesting in place, but really saw a different vision for this. While the plan that you see there on the left side is private and mostly private and exclusive, you know, it looks like it was built, the open spaces and stuff, it was built for the residents. The goals of Asheville Sanctuary were to open this up and to make it more inclusive and invite the community in. Instead of it being a project for the residents and the people working there, the goal of this is for it to be a development that's used by everybody. And that kind of starts, let me walk through a couple more details. So this is another comparison of a rendering of the old one. The scales here are a little bit different. So what you see on the left side, they're kind of at the same orientation, but that's only a portion of the original approved project, while the kind of the view on the right is showing the whole thing. It does give the summary. We're proposing 68 more residential units than what's currently proposed there. And then we're taking that up from the commercial space that we're removing. One of the other big changes, the approved plan on the left encroached significantly further into the Montford community and the north side of the creek. It is currently approved for 29 residential units on the north side of the creek with a max height of 40 feet. We're proposing 2 buildings at 18 units total with a height of 12 feet. So basically, we're using the topography. And so when you come in from Gudger on the parking lot side, you see a 1-story building that then works with topography back towards the creek with the second story underneath it. This is kind of a comparison of the 2 plans. It shows that we've got a 22% increase in residential, 61% decrease in commercial, and 93% in office. What you see in the bottom picture is the massing of the approved plan underneath it. This is an overlay. In orange is the approved master plan. And so what I want you to take away from this is, one, kind of that encroachment I was showing to the north, but some of the more fine, and I don't know if I can zoom in here, but what the more fine thing to look at is, while we're asking city council for some additional height, really not a whole lot. We're going from the tallest building on the approved plan was 60 feet. Urban Village allows up to 100 feet, but the previous plan had a max height of 60. So we're looking to actually take the site and compress it in and go up a little bit so that we can fit more of it, pulled some of the stuff from the north side, brought it into the main area, and kind of reshifted everything so that we could preserve more land to the north and existing vegetation and actually preserve a wider buffer on the Isaac Dixon side, the west side of the site. The approved plan basically went right up to the property line, and we've been able to pull our building. So you can kind of see in this upper left corner, we've got about a 30-foot setback from where what the approved buildings sit from where we're proposing the buildings. And what that's allowing us to do is go and not only plant a buffer along that corridor, but actually maintain some existing buffer and some of the existing trees that are there to give us what we feel like is a better screening from Isaac Dixon. This is the site plan, and we've intentionally kept the Barfield name on the street, the Western Street and the Michael Street. Because of the way it's laid out, where they are today, we've kind of adjusted their locations slightly. The main thing that we've also done to the site is we're taking it down. Right now, if you stood out on Hill Street and you looked at Michael Street, it shoots straight up the hill, and we're pulling that down so that it's at an accessible 5% or less slope all the way in. That road that comes in as you go in, we've intentionally taken that back building, which is one building underground, but it presents as 2 buildings so that it creates that openness and so that you can see all the way through into the forest behind. And that Michael Street entryway from Hill Street includes 15-foot pedestrian zones on either side of the street. As you come into the site and you get to the back building, we've got a plaza that has underground parking underneath it. And then as you turn to the right, on the north side of that east building, we've got a restaurant space there that's open to the public and proposed to overlook the area down where the trail system and the stream will be rehabilitated in that area. There was a comment, we'll see it here in some of these renderings. So basically we have to have no more than 50% of the parking as surface parking. We have, I don't even know what the percentage is, 2%, 5%. We have just the surface parking lot that you see right here. This angle is kind of looking from Hill Street with Isaac Dixon to our left, and we've intentionally put a little surface lot right there because it's going to tie to I'll show you that in a second. It's going to tie to a little grocery retail area that we anticipate the community to be able to use and want to give easy access to. Once again, for comparison, this is our plan, and then the massing of the approved plan. The biggest stark difference was actually the building right up on Hill Street. That was the tallest building proposed in 60 feet. As you see here, I've kind of flipped back around, and Isaac Dixon's over to the left there. This has got Hill Street and the CBD behind us, but we've been very intentional about Hill Street and how we've kind of stair-stepped that building back so that from the public right-of-way, it's not so just kind of looming over top like the approved plan is. And this is the entryway in and Michael Street. The only other place we actually front with a building right up at a public right-of-way is in the far right of the screen is Bay Street. And so we have a parking structure there, but we pulled the building back away from that side so that, once again, we were kind of being able to stair step from the public right-of-way back into the site and move the height into the core of the site, into the central part. The white roof here that you see on the larger buildings, that's that 68-foot height that we're asking for with those little architectural pop-ups of the black squares and rectangles. That's where we get to the 71 that's referenced in our application. And this rendering does not show it, but we are required and will be providing vegetative screening on that parking structure. Once again, comparison of the massing and how we feel like the previous project, while it got you in, and then it just kind of hit a fortress of, this is looking from Michael Street, the grocery retail area there on the left. This is a little bit down on the corner with Isaac Dixon to our left, and while we do have a surface parking lot there, that'll be easy for parents like coming in and out of Isaac Dixon to run in here easily. The grade of that surface parking lot, it actually drops down and goes underneath the building, so it goes into 2 stories of below grade parking, but then we've put a screen wall there so that we're not just looking at a surface parking lot when pedestrians are walking up and down Hill Street. Isaac Dixon's behind us. This is the looking off to the west. Back to Michael Street. Kind of that step back that we spoke about. This is the rear building, the first building of what's referred to as the forest building. You can see the opening straight ahead on the road, and then this is a plaza that we have that'll be landscaped, and there is subsurface underground parking that connects to both of these buildings below this grade. The other building, and then what you see to the right side of the screen is where the overlook, where it kind of cascades down to that stream area, and where the restaurant is proposed, the public restaurant's proposed to take advantage of that connection with nature back there. And then finally, a rendering of the creek building. This is on the north side of the creek. So as I made reference, when you're on the parking lot side coming off of Gudger, it appears as a 1-story building. We're working with the topography back down towards the creek and trail system to put that kind of tuck under that 2nd story, but significantly less than the 40-foot building that's approved there. So with that, that's a summary, and I'm here to answer any technical questions, but I think, and Derek covered it, the things we're asking for city council are those reductions in programming uses, more than 25%, and then we are asking to increase the height of these buildings slightly to accommodate more preservation on the extents of the property.
Thank you, Mr. Day and Mr. Allen. And I appreciate the exhibits, particularly to highlight the changes between what was last approved and what's being proposed. One thing I didn't hear information on, and just curious, is parking spaces. Has there been any change from what was previously approved, or is it the same number of parking spaces, 859, as what's being proposed now?
I don't recall what the difference is between that and the approved one. I'll need to look into it. I don't know I don't have that number off the top of my head. I do know that we are within the minimum and maximum of the current ordinance for parking, off-street parking standards.
Okay, I appreciate that. The reason I asked was just the significant change in programming away from commercial and office use.
Right.
I'm curious in particular if, and if you could speak to whether you feel like it might be a little overparked. We're at, 2.5, close to 2.5 parking spaces per unit, factoring out some for the commercial use, might be around 2 per residential unit in an area that's walkable to downtown. Why the high number of parking spaces?
Basically, we're trying to make sure that as we move forward with this master plan, that we've got ourselves covered, and that anything that we went forward with technical and more detailed drawings, that we've come off that intensity. So we're kind of asking for the most intense that we have. Some of that study is still being done as it relates to whether that ends up being a second restaurant up near the front, which would be a higher parking demand than the grocery, and some of those kinds of things. But that's, right now, it's really what can we kind of fit in there, and we haven't detailed out the actual studies and numbers. So.
Okay. Any questions?
I had a couple questions.
Yeah.
You had mentioned that this new plan is intended to invite people or the public more into the space than the previous. Can you speak to specific design elements that you think achieve that?
So, I mean, primarily the fact that we're bringing the grade down and making an accessible and pedestrian connection into the site. We're also having, can y'all see? Yeah, you can see the arrow.
Yeah.
So we're also, as this is a pedestrian corridor coming in, it also allows us to connect down to the natural area here. So it brings a connection from the trail system that's going all the way back along behind Isaac Dixon, and it connects to that. As Will made reference, there's discussions about continuing more of a greenway and trail around the buffer. Our goal was to actually bring people through the site. And then the connection out to Gudger ties into the Reed Creek master plan that is proposed along Hill Street and Montford in this area. So that was really it, Jason, was that we were trying to pull the folks and tie to the kind of some of those master plan ideas of pedestrian connectivity through the site.
Yeah, I wasn't sure if I picked up on that creek crossing for the trail connectivity in the plans that were submitted, but that's the intention?
The intention is a trail through here. As we had done more due diligence on this, we found that Clearwater Environmental had actually been in the process of permitting a rather large impact with one of the initial drawings out here and building a lake. We're not proposing to build a lake, but we are proposing to go in here and improve the kind of what's now just a
it's like a ravine.
A ravine.
Yes.
That's the word I was looking for. It's a kudzu-filled ravine.
Yeah.
And so we're really looking to take that and actually take and bring some of that elevation up. We've been studying the stormwater and where it's flowing down from and crossing Gudger, and how right now it's just kind of that ravine has formed from where it's just fallen for so long and it's just scoured all that out. And there's a real opportunity to go in there and kind of pull that up and make it more at an accessible elevation where we can enjoy it as opposed to be scared of what we're beside and kind of.
You've been exploring stream restoration to some extent?
Stream restoration along portions of it, but actually even just reconstructing what that stormwater looks like at a different elevation now, because it's really gone down and it becomes a stream where it found groundwater from just years of kind of falling and scouring and eroding away. And so we're looking to kind of work with the Corps and the state and bring that area up as we eliminate the kudzu through there and really highlight what opportunity that space has.
But you are proposing some sort of pedestrian connectivity
Yes,
from Gudger.
correct.
Okay, I just was noting that I
Yeah,
hadn't,
right
wasn't
now,
seeing that
right
on
now,
plan.
we're proposing it, you kind of see a little bit in this rendering.
In the rendering, yeah.
Right now, we're proposing there's a lot of topography issues in there, so we're proposing a trail system, but working with staff on, and Lucy to figure out what that might look like for opportunities in the future. But connecting through our site from Gudger, as well as the exploring that nature trail.
So, right, so, okay, so those are the main design considerations for public access.
Correct.
You are reducing the amount of commercial, though, that may be enticing people into this site from the previous plan.
We are, the vast majority of it was office space, and so that office space got really taken out. But
Yeah, that
we're
makes
also in
sense.
a completely different world than we were when this got approved.
Okay, and then the second question I had is you had mentioned vegetative screening on the parking that's on the east building,
Right.
but that parking, if I'm correct, that parking garage is right on the property line?
No, it's actually been pulled back a little bit, yeah, because we've even got, the architect has pulled it back away from the line. We've got some means of egress, I think, that come out to go around the backside of the building there too. So I don't know if that's represented in all of these images and maybe some of those renderings, but that's our intention.
Okay.
And I think
Yeah, I'm
it
just
was,
seeing on-
it was one of the, I would think it was one of the conditions of the, during our TRC review was for there to be proper landscaping for that,
Okay.
parking structure.
Is
So
that's correct, Will?
What's the question?
the
Part of the TRC conditions that there's screening on that parking garage. Right now, the plans are just showing it pretty close to the property line.
Yeah, there are requirements for screening based on exposed parking deck. That's just part of the landscaping standards in 7-Eleven. So that would be a detail that'd be required at that final.
Could
level
that be
two
as
review.
simple as like a green like lattice and vines, or does that have to be
The code
a
has,
planted buffer?
the code has a planted buffer, but I think it's also got, I know in the CBD, it's got some opportunities for you to do attached vegetation, but either way, it was one of the details that we definitely will have to work out as we move this forward from this master plan stage. But we're anticipating it and have no issue.
Thank you.
So while it's not part of the review, the Hill Street neighborhood, do you have any comment on trying to pay homage to that or anything?
Sure, and that was number one on our list in terms of folks to reach out to, and that's what I did when Will was jumping up to give comments and start the presentation, was talk to the presenters tonight to continue that conversation, because we'd only met with Rashida and with Amy at that point, but that's going to be part of the programming, and Barbara Salk, who's the principal of Be Smart, and our client is going to meet personally with them and get that programming correct. And while it can't be a condition, that's certainly the intent here, and the intent for us has been all along to meet folks for the conversation, to bring them into what we're doing, and not wait for those things to come up.
Specifically, while we're on the topic, and just to kind of add specificity to the programming that we received comment on from community members, it says, we ask that the development include relevant signage, public art, and a mini museum to honor this history. We'd also like the opportunity to hold a grief ritual on the site for what has been lost by our community before any ground is broken for construction. Granted that this isn't a conditional zoning where we're attaching conditions of approval, or are those specific requests of the Historic Stumptown Neighborhood Association acceptable?
Those will be the discussion points. I'm not sure exactly what a museum might look like, for example, to pull one out, but those kinds of things that are in that list are certainly the discussion points and what we are going to commit to doing.
I think, yeah, a mini museum could be as simple as a kiosk of sorts, or, you know, an assemblage of signage that could be in a window front.
There are a thing that would be personally interesting to me, and the reason I got excited on that signage piece is to have markers throughout the site on, you know, things that might have been in this particular community. Like you see historical markers downtown that said, you know, this was located, you know, 2 blocks northwest of here, and this is the significance historical, or in this place, cultural and maybe historical as well.
Yeah, you know, we have them all throughout the city, and I think this would be an appropriate place for that as well. I just want to echo what others have said. I think, you know, we can't attach conditions, but I think our legacy, Asheville's legacy, is important to keep interpreting, and you know, because I have to be honest with this project, although that necessarily is not going to can't weigh in whether approval or not. This is luxury housing, right? And this may be housing for people that are not from this area that come in and buy into this housing, buying those sunset views over the mountains. And so I think it would be very remiss of us not to have something for those new people, new residents to Asheville to come in and see what it is that they're now occupying, the space they're occupying, and the history of that space.
Yeah, I'd like to just take a minute and be specific about the history. The Hill Street neighborhood was redlined, which we hear kind of in this hand-wavy type way of what redlining is. But it was redlined in 1937 by the Homeowners Loan Corporation, which prevented Black residents from accessing mortgage and financing opportunity for homes in the neighborhood. So they didn't have traditional tools to maybe maintain home ownership. But then Hill Street was also then declared blighted by the Asheville Redevelopment Commission in order to further suppress property values and allow for easier right-of-way acquisition for the Crosstown Expressway project in 1960. So when we talk about out-of-towners or people who aren't familiar, they are reaping the privilege of systemic inequity, and that is part of this commission's charter, is to take into account the past and present harms, particularly as it relates to the comp plan and the Unified Development Ordinance, which our city continues to reaffirm through reparations being a priority of our council on an annual basis. So I think it's important to speak about the specifics of how this property became an empty 10-acre parcel within walking distance of downtown Asheville.
I really appreciate both of your comments on that, and even to build further, you know, I certainly applaud the current owner for taking the time to clean up the site. You know, needles and kudzu are indications of neglect. And what's really important about the history of this site is it did not suffer into obsolescence by neglect, but by erasure. And I think that's what Commissioner Wheatley and Cycle are lifting up. And I really appreciate your commitment to continue the conversations with the Historic Neighborhood Association of Stumptown and others who have a vested interest in being welcomed back in, because I certainly agree with what Commissioner Cycle is saying, that this will be high-end housing. Also want to lift up staff's analysis and review, particularly the demographic data and the references to the Asheville African American Historical Resources Survey. Really, really helpful to guide our discussion. A couple of data points I'll pull out of that. The median household income in the census tract is $50,250 as of the 2022 American Community Survey. That is equivalent to a 60% area median income of a 3-person household, which is $50,460. And that represents a census tract that's 1,902 residents, 28% of which are Black, and 8% of which are biracial or multiracial. So the addition of 377 units, while certainly laudable in a great location, will undoubtedly change the character and demographics of this neighborhood. And so it's very important, I think, for the community and for us to acknowledge this change and understand how we can embrace and tell the story of what was there before as this very dramatic change is slated to happen. A couple other things I'd just like to lift up out of the African American Historical Resource Survey on this site previously was amazing vibrancy of a community. The Hill Street community hosted the Hill Street School, which we heard from a community member who attended. Also was the site of the first Black hospital in Asheville established by Dr. Torrance, and the home of Newton Shepard, who was elected in 1882 to Asheville Board of Aldermen, the predecessor to City Council. These are really like amazing historical anecdotes that cannot be lost or tucked away into our historical survey. So I do hope that there's a strong effort to tell this story on the site.
Certainly, and these sentiments and these last three comments in particular, have been, part of the driving force of what we've been doing in terms of our outreach, because, again, this is a project that was approved back in 2008, 2009, and I just don't think these kinds of conversation, this kind of outreach was happening then,
Right.
But that doesn't mean that we don't do it now, and so, while the project's approved, yes, we can go build it, yes, it doesn't mean that we can't have those conversations now and do that kind of outreach and preserve the legacies that we're talking about.
Thank you.
So, given that this isn't a conditional rezoning, it's, we're not putting any conditions on it, given that obviously you're passionate about the history of this area. I believe you live in Montford, last I knew. So you're nearby and have some buy-in as a community member. How do you see this? Yeah, that's right. And so how do you see the master plan philosophy of UV being able to roll in these concerns in a way that's meaningful to signal the council, who will be the final approval, and signal to the community that it's rolled in a permanent way that can be tracked and understood?
Certainly, the biggest part of it is, it is a conversation, and, that conversation is, how do we change the entirety of this plan? How do we update and amend this master plan that's already approved in a way that makes sense for our community in 2024? And that's, through the uses, through the placement of things, through inviting pedestrians in, through recognition of those cultures that have been erased, and doing that in a meaningful way. And the only way that I know how to really do that, the way this is set up, is to invite them into the conversation, from all the different interest groups. And, whether it's Dave Nutter talking about, how this trail is going to look in the back, or the folks at Christine Avery, trying to find a new place for their school, or if it's, Stumptown trying to find recognition and making sure that we are honoring what was there. That's it. I mean, that's the conversation.
Yeah, and I dig it. I guess more specifically, you referenced I'm going to ball up what it's called, but the Black History walking trail through Asheville. Is that something where, say, the community is amenable to I'm going to say an air quote, an outdoor mini museum that would have, 4 to 6 monuments on site? Is that something where you could perceive a master plan including kind of like designated monument locations, or?
I think that's a great idea, but one of the things that also we're being careful of is to not program it on our own without having that buy-in. We don't want to get in a position where we're saying, hey, here's the programming that we provided based on what we thought it was, instead of actually knowing what it is and having, real meaningful dialogue on that.
Could there be vague language, though, that's somehow embedded in the master plan?
I don't know how that would look on a master plan, because it's.
I mean, a master plan by nature is vague.
Yeah.
Yeah. Well, and if you can adjust the use by type by 25%, you could probably adjust the, signage, public art installation, those sorts of words by 25% too.
I think what we can do is, provide by the time we get to council, and we've got a council over here, by the time we get to council, we can have some commitments that are, things that we can articulate, that are things that we have, work through and have that are committed to that. Because, one of the things as we're rolling this out really for the first time to the public is kind of now in this process, is making sure that we haven't put ourselves in a box that we can't back up from. So we want to make sure that we get them right and have the right authors in it.
Yeah, I think it's super cool and really meaningful to put community voices as close to the center of that activity as possible. I appreciate your openness towards that, and also would add that communities that have faced intergenerational trauma, who have, interacted with this land and community in a different way, have an emotional drain that comes with those conversations and emotional labor that sometimes folks aren't cognizant of. And being vulnerable and showing opportunities to engage with them and being transparent with that level of engagement can be encouraging and can allow for what has been called ethnogeneity, which is, the opportunity to actually recreate culture, bring culture back into a community. And, I would just implore you to continue the brave steps you're taking now to engage the community openly and be really available with what they can ask for and how they can engage the process.
Certainly.
Any other questions, comments?
Thank you.
Thank you. With that, I would like to reopen public comment on this at 6:59. Would anybody like to speak on this matter? Seeing no one sprint to the mic, I will close public comment at 6:59. Any other final comments?
I would just like to thank members of the community who did submit public comment online, particularly Ms. Worthen and other members of that Stumptown community. I mean, it's always great when we get public comment. It's especially great when we get articulate, clear, detailed public comment, which I thought was really good in this scenario. So thank you for that out there. But I'm prepared to make a motion unless there's other discussion.
Any other comments? Seeing none, take it away, Commissioner Fairclough.
I move to recommend approval of the Urban Village Master Plan amendment requested for property located at 99999 Hill Street and find that the request is reasonable, is in the public interest, is consistent with the city's comprehensive plan, and meets the development needs of the community in that the request, 1, provides infill development in targeted growth areas, 2, encourages large-scale land assemblage and integrates these developments with the surrounding area, and 3, increases the rental housing supply.
Second.
We have a motion and a second. All those in favor, please say aye.
Aye. Aye.
Any opposed? The motion passes unanimously. Best of luck with your development. So the next item on our agenda is a request to rezone property located at 107 Glendale Avenue from residential single-family high-density RS8 to residential multifamily high-density RM16. The property is identified as PIN 9658-20-6956 in the Buncombe County Tax Record. The property owner is New Vision Trust. Applicant contact is Mr. Hiram Wells. Planner coordinating review is Will Palmquist. Mr. Palmquist.
Good evening again, Commissioners. This is a straight rezoning petition for a property at 107 Glendale Avenue. You can see the property highlighted here on the aerial image and also on the vicinity map. It's kind of in the Oakley neighborhood, close to the Swannanoa River district as well. property is 0.89 acres. It's currently the site of a single-family house that appears to be unoccupied. There are single-family houses nearby, a few new houses actually on these lots to the north as well that were constructed in the last year or so. So the existing zoning is residential, single-family, high-density RS8, which is what most of the area to the east and north is zoned. The property owner is requesting a rezoning to the residential multifamily high-density RM16 district, which is what the property to the west and north of Glendale Avenue is zoned. The existing future land use in the city's comprehensive plan is traditional neighborhood. No change in that would be required for this rezoning. Commissioner Wheatley requested some more information about the missing middle housing study strategy areas. So as kind of a refresher on missing middle housing, as part of that study, an analysis was done based on change in housing costs, prices, sale prices, that sort of thing, about where markets in the city are either changing a lot or staying more stable. This is right near an area in Oakley that is experiencing what's called high vulnerability and high change. So it means that gentrification is already happening here. It means that pro-housing policies should be implemented thoughtfully in order to minimize acceleration of gentrification, and that the city should consider strategies outlined in the report to mitigate displacement risk. So while the study is not a policy document guiding rezonings, it's an important piece of data that we appreciate being brought to our attention to include in this presentation and food for thought, not only for this rezoning, but for future policies as well down the road. So this is a chart comparing the RS8 to the RM16. You can see the RS8 in the center column, RM16 on the right. Really the most major difference, of course, is the types of residential uses that are allowed in the RM16 district. So they both allow for single family and townhouses. RM16 allows for duplexes and multifamily development in addition to that. RM16 also has a couple more caps on density and structure size, and both districts have the same lot width, building height, and building setback requirements as well. So staff has identified a couple pros associated with this rezoning. The rezoning would allow for development of more residential units in a variety of housing types as compared to the existing zoning district. Also, it would not cause the existing single-family house there on site to become non-conforming use or feature, since single-family is allowed in RM16 and they have the same form setback requirements. They wouldn't have a non-conforming issue if the single-family house was to remain going forward in any case. So as far as the compatibility of the RM16 to the area, I just pulled the description of RM16 from the UDO. It talks about a full range of high-density multifamily housing types. It's intended that this district be located near employment centers, shopping facility, et cetera. So it's kind of closer, to that Swannanoa River, Thompson Street corridor to the north. The overall rezoning is compatible with the surrounding zoning districts, as previously mentioned, as well as the commercial industrial districts that are located to the north and west of the site. It's also consistent with the comprehensive plan land use map of traditional neighborhood, which speaks about the types of housing that can vary, often include a mix of housing types such as single family, duplexes, townhouses, multifamily, et cetera. The rezoning would also support a number of goals in the plan, including to encourage responsible growth by prioritizing greater densities and development overall throughout the city as appropriate, to celebrate the unique identity of neighborhoods through creative placemaking by continuing to support contextually appropriate infill development in a variety of housing types, and to increase and diversify the housing supply by promoting zoning policies to encourage more housing by expanding areas permitting higher density development. Therefore, staff recommends approval of the proposed rezoning. I will have to answer any questions you might have. We might have the applicant with us this evening. I've not met them in person, so I don't know them by face, but they may or may not be here, but I'll fill in as best I can if they're not.
Thank you, Mr. Palmquist. So one question about the specific request to rezone from RS8 to RM16. RM16 was deemed appropriate because of the contiguity with other RM16. Is that a fair statement?
I mean, I think the main basis of the consistency is the comprehensive plan and the future land use map. So, you know, the fact that it's that traditional neighborhood speaks about a mix of housing types that go beyond single-family houses, and also RM16 is a cited appropriate zoning district within that future land use category. I think are cues to our comprehensive plan that a more diverse and a more dense style of housing could be appropriate in these areas. It's not to say that if it was one property down, it would be, you know, dead in the water. I don't think it's necessarily only due to the proximity, but I think the cohesion to that area, I think definitely helps in a logical kind of way as well.
But say versus, you know, RM8 or, you know, we're splitting hairs here on the uses are this consistent across RMs, but.
I think, yeah, I think it could, either could be appropriate, and if they're requesting RM8, it would not be inappropriate either, in my opinion. I think the applicant probably requested the RM16 due to the proximity and felt that it made more sense and was probably a more, I'm speaking for them now, but I could imagine them seeing that as a more logical continuation of that district and therefore could potentially be better received. So that's definitely a consideration.
And we did receive some public comment on this in advance from a neighbor. One of the items they flagged was that a proposed rezoning, you know, we're not evaluating a specific development plan here, but a development proposed under RM16, would it be required to add sidewalks? That was flagged. There's no sidewalks there currently. By the rezoning, would we be creating, you know, kind of like one parcel length worth of sidewalk expectation?
Right. It would depend on the details. I believe for multifamily, sidewalks only required if there's 10 or more units. So that would be a break point depending on the scale of any proposed projects. I'm not sure if the project could apply for, would be appropriate for a fee in lieu, meet those requirements. There are some criteria like traffic and that sort of thing along the street that could potentially be applicable for fee in lieu. That might be a good avenue for the project, but it would depend on how many units there are proposed. So it's possible that there could very well be a sidewalk required that currently would not go anywhere.
Thank you. Any other questions for Mr. Palmquist?
I just want to note, I think that was left out of the presentation, that could be added anyway, is that the Phase 1 of Swananoa Greenway, starting at Glendale and Thompson Street, is set to begin construction at the end of the month. And that might be valuable information connected to this.
Absolutely. This area is really not that far from that kind of, you know, center of activity and other uses up to that north. So, yeah.
With regards to the comp plan and just kind of the zoning map in general, do we know when the last time the zoning map in this area was updated for like this area in general between RS8 and RM16?
I don't know. It's probably been pretty consistent over time. I can't imagine it changing a lot. So yeah, it'd be hard to say, but I could speculate that it probably maybe hasn't changed since the UDO was adopted. I don't know. It's hard to say without researching it.
Yeah, it's interesting because a question could be, should all of this area be RM16? Would that be applicable if somebody had that much land there?
Yeah, it's definitely something to think about. I think it's definitely a future consideration of our ongoing zoning text amendment project to consider, once we have better anti-displacement strategies and other mechanisms in place, is to consider all these residential single-family type zoning districts that are near these centers of activity that are opportunities for a different style of development than maybe what's traditionally been there over time. It's definitely something interesting to think about for sure.
Well, it's interesting because Glendale Avenue is a relatively small, not to besmirch anyone's good name, but poorly maintained road that doesn't even have clear center marking on it. That currently up to Dogwood Lane has some kind of mixed use, but even once you get past, there's a warehouse there that's been renovated, but once you get past that, there's new single-family home development that is on the market for $750,000 per single-family home. So that's the 4 lots that are cut up just to the east of the lot we're talking about.
Sure.
So why that could be important is that within the demographics, there's a couple of interesting things here where you see the average median income of this census tract is $56,000 a year, which would be a mortgage probably around $1,500 a month, which is about, to not be housing burdened, $230,000 per unit. So essentially the current market rate for a single family home in that area is triple what could be even considered affordable. That being said, moving from RS8 to RM16 significantly decreases the amount of road frontage required along the main street and decreases the lot size from 4,000 square feet to 2,500 square feet. In other words, in an ideal world, maybe we're dreaming up missing middle housing and duplexes and, small, affordable apartment units. And then it also is another world where, this 0.9 acres gets rezoned, the single family home gets a permit pulled to demolish it, and it's subdivided into those 4 exact rectangles to the east that are now 4 $750,000 homes on the area which is defined right on the edge of the highest vulnerability based on the anti-displacement component of the missing middle housing study, which I believe, and we have a council person here who could speak to it, anti-displacement is currently at the center of our lens for not only text amendments, but I would also guess rezonings. So that's kind of a monologue, but it's also the situation that we're presenting from another angle.
Yeah, it's interesting. I don't think this opportunity to subdivide would increase. Both districts require the 40-foot wide lot minimum. So I think any way you slice or dice it in either zoning district, you still have the same number of lots that could be created. But I do see your point, and it's maybe the question mark with the straight rezonings. You don't know what's going to come down the road, and we have to trust our UDO, and future changes we make to it to make it better would then be applicable in this case.
Okay, so just following the thread that you were pulling on and what you just said, I just wanted to clarify, because I don't have the table right in front of me. The rezoning would not decrease the amount of road frontage required? So
No,
the subdivision would
so
be identical?
the lot size is smaller for RM16. The minimum lot size is smaller, but the lot width minimum is 40 feet.
Okay.
So those are basically the two criteria,
factors.
yeah, for subdividing, so, but.
And without breaking out the land calculator and things like that, somebody sharper than myself might be able to understand if there were opportunities for flag lots associated with, changing lot size requirements and things like that. So I do think it's a little bit more of a moving target than we might initially think just off of road frontage.
Yeah, that's a good point.
Also like to point to the demographics of this area where 20% of the existing residents are black, which is double the rate of the rest of our city. And another 10% are Hispanic. So that would be, 30% of the population being BIPOC. And I think, based on the overarching demographics of our city, that is meaningful and could signal some level of displacement that is a little bit hard to peel back in any one situation. But I do think it would, it's advisable to take these things into account when we're making modifications, especially where we have reports basically signaling that we should use greater caution. And that's also been requested of us by council.
Appreciate those comments. For me, what this application is seeking to do is achieve greater flexibility of uses and provide for an opportunity to potentially, and again, we don't know this because we don't have a specific development plan, but accommodate a greater level of infill opportunities. So I understand, and I think the questions are really valid. For me, this is kind of like one of those stopgap rezoning requests we're being asked to do because we haven't fixed the overarching rules of the UDO.
Yeah.
So, sorry, I want to interrupt real quick. On the application, it does say the subdivision plan has been submitted to the Asheville Planning Office. Was that a misspeak on the applicant?
There's a pending subdivision plan, and yeah, I think it's, I guess, stalled out, for lack of a better word. So I think that was an avenue that they were pursuing at one point and are changing courses with.
So that's old information. Okay.
Yeah.
Gotcha. Sorry to interrupt.
No, I appreciate that.
I just wanted to make sure we weren't like talking around what we had somewhere.
I mean,
good pickup.
Yeah, it would be interesting to know if that does have any impact. I don't know enough about it, but if that application is purely on hold to see if they can get rezoned, that's interesting and potentially meaningful information.
Well, the application would have a plat associated with it, right?
Yeah, exactly. Would that not be relevant meeting documents?
Well,
not for a straight rezoning, but yeah, we're being asked to approve or deny a rezoning request that would accommodate the range of allowable uses under the UDO, and staff would be empowered to apply that.
Can we just double check the applicant is not here? Okay, I'm just making sure.
Thank you.
Well, I wanted to pick back up on something Commissioner Wheatley had mentioned, which is, I guess, would it be suitable for this whole area to be RM16, considering the impending density of uses and the growth of this area? And, I know we're looking at just this one, but is this the kind of the way that we want to be approaching this, is kind of one rezoning at a time? And, should we be looking at making sure that our zoning map is properly up to date. If we agree, you know, looking at each one of these rezonings one at a time, that they are appropriate, you know, I think that disadvantages people by not having a map updated to people who can afford to come forward with this process.
That is
But isn't
such a
that-
great point.
Isn't
yes.
that what we're doing though with the UDO stuff outside of this particular applicant, that we're going to be looking at neighborhood-based rezoning to support housing supply and affordability goals? It's just not the first step in our UDO bundles.
I've not heard
So I think
that.
it'll be a matter of time.
Yeah, I've heard that.
I've not heard that.
So, yeah.
Well, what we've been saying at council meetings, we also have on the 24th of September, a council work session from 3 to 5, that we want to have 2 trains going next to each other at the same time. They start with looking at high density on corridors and commercial districts in one train, and looking at anti-displacement programming in the other train. So same time, they look different. There'll be zoning in kind of the mixed use, in the transportation corridors and commercial. That'll be kind of more zoning and regulatory things. We anticipate that anti-displacement will be more programmatic, like rental assistance programs or home repair programs, what have you. So those will chug along, and we'll do this very much in collaboration with our highest vulnerability neighborhoods from our missing middle study, okay? So chugging along, and then at some point, we're gonna have some awesome programs in place that will prevent and create counter incentives so that folks who want to stay in their homes can. Then after we're done the mixed use, it's late, we're all tired. The corridors, then we will move into neighborhoods. But we are not eager to move into making zoning changes in neighborhoods at the broad scale zoning map until we have displacement things in track. So I fully anticipate neighborhoods like this will be looked at. We will revisit what our missing middle strategies are, what our zoning strategies are, but we don't want to do that until we have some programming in place to support those to basically have government intervention in the market so that we can meet community benefit with government support while we're also setting regulatory standards different. So that is the path. And so I would expect, within 6 to 9 months, we might be looking at this very neighborhood for this very conversation of should this all be RM 16? But I think council is signaling we need to pause until we get some of the displacement stuff in track.
Thanks for that context, Councilperson Ullman. That's really helpful. Given that, is council signaling pausing all residential rezoning efforts until that work has been done? Because
I haven't heard that.
Okay. To Commissioner Cycle's point, the urgency of this, and I appreciate the timeline you laid out, is in the meantime, we are reliant on the piecemeal approach from developers of means. And, there is some inherent inequity in that. So for the council work session, I would love it if you could kind of convey back to council that we have a contemporary case study in the challenges with what is currently embedded in our zoning
The
map.
River District also, not long ago, and we voted on that and had discourse. So, I think it's a good work session for everybody to tune into. While we're on the topic, I'll also note that we're promoting these bonds and asking residents to pass bonds on the ballot in November. 20 million would go to affordable housing. But if those don't pass, we're not really sure where budget money will come from for these displacement programmings. Programmatic dollars are money we need every year, but we can move what's currently some capital spending from our general fund to be paid for with bonds. So we're really hopeful that that message and that the community understands if we pass these bonds, it's not just what we're going to pay for with those, but it opens up a whole new way for us to leverage our general fund so we can really double down on things like displacement so that we can do both and pursue affordable housing, anti-displacement stuff, and supply at the same time. So, thanks for
It's cool you mentioned that because I don't know how others on this commission feel, but I'm really interested to have a report from council or staff or whoever would be willing to engage, some of the outcomes of the last housing bond that went through and the successes that we can kind of uplift and discuss and use this as an opportunity to say like, wow, we did a great job the last time and let's keep doing great work.
My understanding is all boards and commissions will have the opportunity in the coming months to have an agenda item, to have a presentation from staff on these topics, so.
Super cool.
Yes.
And I think we already do have a plan for the affordable housing plan to come to the October meeting, which might be a
But
good
specifically
thing.
the bond?
Well, same staff person, so maybe we can send some
Yes.
advanced signaling that we'd like to.
I've seen a lot of what the presentation looked like. There is some information in there that you're looking for, definitely.
Great.
Yeah, that's the thing that I've heard before is just that folks don't necessarily know how that bond money went into the community last time.
I got a
And
document I'll send to the full commission after this that we're using with the campaign out in the community, so.
super cool. Thank you.
Thanks. All right, so back to this rezoning application. But I thank you for
Yes.
providing that added context. I guess without the applicant here, I'd open for public comment at 7:28. Would anybody like to speak on this matter? Seeing none, I'll close public comment at 7:28. Any final comment or deliberation?
I'd like to make a motion.
I will entertain one.
I move to recommend approval of the rezoning request for the property located at 107 Glendale Avenue from residential single-family high-density RS8 to residential multifamily high-density RM16, and find that the request is reasonable, is in the public interest, is consistent with the city's comprehensive plan, and meets the development needs of the community, in that the request, one, prioritizes greater density of development overall throughout the city as appropriate, two, supports contextually appropriate infill development and variety of housing types, and three, promotes zoning policies to encourage more housing by expanding areas permitted high-density development.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed?
Nay.
Motion passes 5-1. Thank you, and thank you applicant, wherever you may be. All right, which brings us to our final agenda item, a request to consider proposed zoning text amendments to section 719 and 7-2-5 of the Unified Development Ordinance to update the standards for tree canopy preservation, planner coordinating review. Chris Collins, Mr. Collins.
All right. Good evening. I am Chris Collins, City's Planning and Urban Design Department. And this is our final agenda item tonight. Gotten a lot done today, so it's good. But I'm going to take you through the current year updates to the tree canopy preservation ordinance, and that's also known as Article 19 within the Unified Development Ordinance. All right, so talking about where we are, so this is progress to date of August. These numbers were pulled for the Urban Forestry Commission, so this is almost to date. But we have seen the Article 19 rollout result in 2.4 million calculated square feet of canopy preserved on development plans, 336,850 square feet of calculated canopy credit planted, and collected nearly $500,000 in tree fee and lieu funds from the program so far. These numbers, why they're important and why they're important to what we're going to talk about tonight, is this. The whole way this ordinance works is using an incentive-based program to incentivize developers to preserve trees over planting them, and further incentivize both of those over paying a fee in lieu. And as you can see by these numbers, it's not apples to apples. Some of them are dollars, some of them are square feet. It does clearly demonstrate that that is the way the preference is breaking out on this ordinance compliance. So what are we going to talk about tonight? We're going to talk about the introduction of the concept of heritage trees. That's going to be a definition that's introduced for larger kind of specimen trees that are important examples, important canopy producers. Some updates to the applicability and exemptions section of this article. The introduction of a new measurement option to make this more flexible, to make compliance with this ordinance more gain flexibility. Expansion of the tree removal permitting program. And a few lessons learned for staff, missed code opportunities, and clarifications that we know that we need after a couple of years of administering this ordinance. So let's talk about heritage trees first. We've added a definition that is based on the size of the tree itself to the proposed ordinance. We have added a requirement to show them individually on the site when they are within a disturbance area. That should be there whether the trees are, I just stopped and thought about something. Okay, let me finish that sentence. Whether the trees are being elected to be permitted to be used for canopy credit or not. I just answered a question that was out there already. And then we get into the incentive system of trying to get these heritage trees preserved. So right now, Article 19 has a table that gives a certain amount of credit for each size of tree that is preserved on a site. Already that table gives you more credit for preserving a tree than for planting one, and it gives you more credit the larger class of the tree you preserve. In this case, when you identify and preserve a heritage tree, the ordinance will offer 200% canopy credit there. So if normally you would get 1,600 square feet of canopy credit, the heritage tree is going to give you 3,200 square feet of canopy credit. Clearly, that means you need fewer trees to meet your numbers. So there is a strong incentive there for preserving these trees. It won't always work. Sometimes it might just be right where the building was going to go, but the hope is that it will help preserve them. In the inverse, there is a disincentive for removal when these trees have been protected as a part of a tree canopy plan or any other zoning related tree. As you'll see with the permit updates in a minute, there will be a 200% canopy credit replacement required for a removal permit. So you're getting more square footage, but you're going to have to put more in if that tree comes out. Looking at applicability and exemptions, this is the first section of the code there. We have proposed an expansion of existing buildings, and we've proposed a change to the expansion of existing buildings and open uses of land. Right now, that's a flat number, and that's almost always in my brain what that number is, but I believe it's 1,500 square foot expansion for buildings, 3,000 square foot for open uses of land right now. That's come across as problematic for some larger sites and things like industrial development sites where a 1,500 square foot addition might represent a very small percentage of the building and the site itself that is actually causing an entire compliance situation for a large parcel. We've come across that on a few industrial sites. We've tried to use common sense and interpretations to get there, but we did want to propose to codify something that would make it better. It's now a percentage-based expansion with a 10,000 square foot base. So you're not going to expand over 10,000 square feet in any situation without complying. But there are percentage-based numbers that get you there. And that does allow us to have a more rational basis for large buildings and sites. We have updated the table to clarify that parks and recreational uses do require compliance. We have been doing that in practice, but it has been unclear to some people, and really this one makes staff's job easier. And does exempt publicly funded transportation projects and on-property governmental and utility easements. Now, I'm not talking about a self-subjected stormwater easement or something else that someone puts on their own property. These are easements that would not allow the property owner to commit to the preservation of a tree within them, right? Because they don't have control of that within that easement. What this provision does is allows that amount of land area to be backed out of the calculation as well, since we're not allowing the preservation trees to go in there. The clearest example of that is railroad right-of-way on a property. We've run into that a lot, where you may have 20, 30 feet of your property actually encumbered and under the control of Norfolk Southern. The ordinance already says you can't use that property to put a tree in. Well, you can, but you can't claim credit for the Article 19 for that tree. because you don't have control over whether or not that tree remains in perpetuity. All this provision does is says, hey, we're also going to let you take that area of railroad right away and take that off of the lot area you're using for calculating compliance. New measurement method was mentioned. This is in addition to the current tree survey where we go through surveying each individual tree we're protecting, cross-referencing the table, and determining our credit for canopy. And it goes additionally onto where sites over 2 acres, we allow for measurement using an aerial photo and GIS software. This is a direct canopy measurement method of compliance, and it does allows for more accuracy, right? So if you really want to get down to the bones of how much your square footage of canopy that you're actually preserving, this will let you do it. It also often will allow for more credit for larger trees, right? So you may have a tree that's not a heritage tree, but it is bigger than 1,600 square feet of canopy. Direct canopy measurement will give you something more than that 1,600 square feet. And again, taking us back to that increased incentive for tree preservation, right? And this is added as an additional option on all sites. Expansion of a tree removal permit. Tree removal permits were introduced with the original introduction of Article 19. Right now, that only applies to trees preserved to satisfy the requirements of Article 19, tree canopy preservation. We do have trees in the UDO that are required by Section 711.3, kind of what the general landscaping code is. We also have trees that are required to remain by Section 712 for steep slope, also some stuff with aquatic buffers there also. In the past, we've had some kind of unclear methods to review and approve the removal of those trees when it's warranted, and really not a logical and rational way to say you've got to replace it with this. We've done this with kind of revised level 1 site plans and things like that. The ordinance really simply says, at this point, let's take all those zoning required trees and make them eligible to go through this tree removal permit process, which is very simple, requires an arborist opinion that the tree needs to be removed, and then also requires a replacement of that tree and a replanting plan. So that would now be for anything that's required by the UDO. So there'd be a clear process to go through for that, rather than some sort of amended site plan. A few of these things, a lot of this has been cleanup, codification of things we're doing now, lessons learned, codifying a 20% critical root zone encroachment that has been allowed by interpretation since we put the ordinance out. Requiring the aerial measurements be done by GIS measurement, so we get some accuracy ensured there. Requiring that when a fee in lieu is used for fulfillment, that they still give us a TCP plan and tabular data on how they're meeting their requirements. That's for our data collection, so we can keep updating the Urban Forestry Commission effectively on what we're bringing in on that. There is something to require critical root zones on boundary trees, trees that have root areas crossing property lines to be shown on a plan. Some simple clarification on how to record the tree preservation plats, and lots of other clarifying language and cleanup. The only other definition that's added is, you've heard me say it already tonight, open uses of land. We're proposing to add a definition for open use of land so that there's not any ambiguity there. August 2nd, 2024, the Urban Forestry Commission recommended approval by unanimous vote. And the next stop for this is you all here at the Planning and Zoning Commission, seeking hopefully a positive recommendation to move forward to City Council for final approval. Okay.
Thank you, Mr. Collins, and certainly appreciate staff's work on this and the work of the Urban Forestry Commission. This is highly technical language and application, so it's a very confusing part of Chapter 7, and I just really appreciate the diligence of the Urban Forestry Commission in working with staff over many months and years to get the proposal to where it is tonight. Certainly appreciate the opportunity to also learn areas of the UDO that I had a working knowledge of, but not as deep a knowledge, so thank you for your presentation. There were a couple of questions from members of the Urban Forestry Commission that came to us after their vote, after kind of reviewing and understanding the language that was approved unanimously at UFC, in particular around the heritage tree surveying application. Could you speak a little bit to when the heritage trees are required to be surveyed and present on the tree canopy preservation plan?
Yeah, absolutely. So I paused for a minute in my presentation because I realized in the midst of late last week and this week, I may have caused some confusion for, at least in communication with one of our urban forestry commissioners. It is staff's intent to have heritage trees shown on the plan when they're within the disturbance area of the site, whether they're being used for credit or not. And that may have missed the markup ordinance, but it is our intent for that to be in there. So I know that was one question that came across.
That's great. Thanks for clarifying that. I think it is present in the language in 719.4, but then the reference in 719.3 kind of isn't super consistent. So that might be an area for just further clarification before this goes to council. And so when you say within the disturbance area, that would include the building footprint in addition to, you know, any site graded area. All heritage trees that are within the disturbed area would be required to be
Yes, and I think that was a plus when we've had some sessions with the policy working group of the Urban Forestry Commission, because it would require protection around those trees if they weren't being removed, and then we would also be collecting data on their removal if they were being removed, so.
Thank you for that clarification. Another question regarding critical root zone, and you mentioned the boundary trees. So it seems like the language that is being proposed exempts encroachments to the critical root zone if there's a conflict with building envelope on the development site. Could you talk a little bit about that? So are we, and I can read it or you can pull it up, but the way I read it, it could be sort of counterintuitively driving strategic building placement to overlap with the critical root zones so that those boundary trees don't have to be preserved. But tell me if I'm reading that incorrectly.
Which section are you on?
Sorry,
so
this is section 719.4.2. It says boundary trees with a critical root zone that encroaches onto the subject property shall be shown and associated tree protection measures shall be employed unless such CRZ conflicts, there's a minor typo, conflicts with a building envelope on the development site. So could you just talk a little bit about that last?
Sure. Sorry,
Unless.
I think of my bearings on it.
Chris, I can jump in if you're not.
Yeah, you did help me with this one. So.
The conflict identified here was that we have certain zoning districts where you're not going to have a setback from wherever a tree might be. And so if we've got like the central business district where you're allowed to build up to the lot line, if we have a provision in the tree-related ordinances saying that you have to protect an area on your property from any disturbance when there's a tree on your neighboring property, and we also have a set of ordinances saying that you're allowed to build right up to that lot line, you're effectively taking away that option of building up to the lot line for anyone whose neighbor has a tree. So that was the conflict that was being contemplated there.
But that makes sense. I appreciate that explanation. I guess the question would be, you're always allowed to conflict with the critical root zone. The question would be, is a developer not subject to, encapsulating that impact within the
plans?
Yeah.
That might be a note for change, because we could probably account for that. the intent was mainly to allow the building to still reach the full extent that it's allowed to within the zoning district, but we could certainly build in language to say and show the extent of a conflict with neighboring tree root zones.
I agree with that, simply because, let's say, 40% of the critical root zone is impacted on the boundary. They may have the right to do it, but they may also kill the neighbor's tree.
Yeah, and they still could, but to your point, if we show it, maybe that would help streamline whatever subsequent dispute happens between those
Yes.
two about, yeah.
So we're looking just to still show that zone, even if it's being impacted. Okay. That can be done.
Great, I appreciate that. And then the final question from members of our Forestry Commission was around permits submitted for tree removal. It was, I guess, your second to last slide. Right now, how is that permit data captured, tracked, reported? Is there any role or ability to sort of make that, transparent or, within the public domain?
Yes. Well, so it's tracked with our Excella permitting system right now, which is not a helper. So the data's in there somewhere in some form. It's not very easy to make available transparently or on demand right now, and especially right now because we're kind of on hold on making any changes to the Excella system because we're in the process of implementing a new permitting system. Now, what I will say about the new system is one of the things that it's best at is real-time reporting of data that's in the system. Whereas you don't even have to build a report. You just query what you want. It's like having Google for your permit system, kind of, but better. So when that comes online, that's going to be much more searchable. Right now, the data's all there. Staff who have the pleasure of working with this permitting system every day are very good at getting data out of it. So we're happy to fulfill a request for the data at any time. It's just hard to make it kind of an on-demand, transparent product right now. But it's all there. Every tree removal permit is tracked like every permit in the city, and the data is accessible.
That's great. And with the new system, there could be an opportunity for, sort of periodic report backs or even just check-ins by anyone.
I mean, hopefully there would be a link where somebody could go and say, let me see what tree removal permits were pulled last week,
Great.
But it will get easier.
When will that be online?
So it's not my project, so I don't have the date right in my mind, but I think we're still, it takes a long time to do these things. I think we're still like a year out from go live, at least. But don't quote me on that exact date yet. I'm not in the DSD world anymore.
I already set my calendar reminder.
September 4th, 2025. Well,
Too late.
I heard a year out or least, at least.
Yeah.
He added the at least.
Yeah, recover, but that at least part.
Yeah.
Thank you. I really appreciate the clarifications and the added thought to critical root zone. I think that's helpful. I'd love to hear what others have to say. I do want to just applaud the notion that we're incorporating, a heritage tree designation that could actually have meaningful impact on preservation, since the name of the ordinance is tree canopy preservation. So this is really helpful, rather than just driving developers to, plant saplings to fulfill validation. But
I'm struggling personally, though, to see how much of an impact that it may have, because we're not saying that these trees need to be preserved. We're just counting them towards credit, correct?
Yes, so way back when, pre-COVID, when we started working on the tree canopy preservation ordinance with the Urban Forestry Commission's policy working group, which I think has changed composition a lot since then, we came into a room and we started with, we don't want them to be able to cut these trees down. But when you get there, I'm going to try and make this really high level, like you can actually be taking the utility of a property, which we're not allowed to do. If you just say that, because that tree might be in the only place somebody could build a building to get reasonable use out of their land. And that's like, it's more complicated than that, but that's the basis. So where we landed after months and months of work and then a pause on trying to figure out how to do new ordinances during COVID lockdowns and all that, was the way to go was to try and provide heavy incentives to preserve those, to not cut the trees down, right? But provide options to do it other ways. And you'll see that in the ordinance, and because you get more credit for preserving a tree than you do for planting a tree, right? Because your requirements are lower when preserving a tree than when planting a tree. And because honestly, the fee and lieu numbers are based on raw land values, and it's expensive.
Sure.
Yeah.
Right, but you can plant trees like in lieu. You don't have to do fee in lieu. You can
Right.
plant in place.
Yeah.
The reason I'm not necessarily bringing this up to say, you know, we should be preserving them, because I do agree that they could be taking utility away from a property. The only reason if you just do the math on it, I'm wondering, I'm speculating on how heavy of an incentive it actually is.
Mm-hmm.
Because at 200% of a large tree, you came out to 3,200 square feet,
right,
which is about 5.5 planted 2-inch caliper trees. You know, which roughly comes out to about $1,800 for a contractor.
Well, so when you look back at the tables, there are two separate tables, one for preservation credit, one for planting. So were you basing your newly planted trees off of that already, or?
Yes.
The credit?
Yeah,
Okay,
the
'cause it's
credit,
something like 300.
560 square feet.
Yep, for a large.
For a large tree versus the 3,200.
Yep.
Yeah. So it's less than 6 trees. I mean, they would plant 6 trees at $300 a piece.
So you would be advocating for a higher percentage than 200?
I just think, I'm just speculating at how much of an incentive this actually is to preserve these trees.
Is the 3,200 set by table, or is that like what we?
It's set by table. It's 200% at the highest number. So that's 3,200 is the maximum you could achieve.
So a question for Chris might be, would the 200% apply to the new measurement technique of actually measuring the real crown of the tree? Would you also be able to 2x that?
No, because the table stops at 10 plus inches.
Right, but for the area of canopy in the protection, sorry, we co-wrote the ordinance, so we get like very in the weeds on this. But so so if we've got the option of being able to measure out the crown of the tree, is that 200% multiplier available to say like, okay, well, most trees are 3,200, but this one is in actuality, whatever, 4,000, and then you get double that. It might end up having a greater impact than if you're just going off of what's in the table.
So as it's written now, I think it's just for canopy credit off the tables, but I mean, there's that, I mean, we could bonus. You're gonna get the full canopy of that heritage tree if you do the direct measurement, which is gonna be big, probably.
That might be a change to get.
Yeah.
For example, 50-foot diameter canopy tree, if you do the 200% to that, that's 4,000. And 50 foot's not unreasonable for a canopy of a tree. And that's well above the 32 maximum that's currently in there.
50 foot.
Diameter, 20-foot radius.
Yeah, I mean, I'm happy to increase the goal is to preserve the heritage trees,
Right, and that, I agree, and that yeah.
So clarifying that the 2x multiplier would apply to the actual measurement of the canopy of a heritage tree as well. Is that the suggestion?
I'm all for that, yes.
I thought we were already doing that, so I'm.
Okay. That's easy to do, so there we go.
Yeah, I just got to say, I hope UFC put a lot of time and energy into it. It sounds like they did. I've got to lean on them and trust them and their special, focus and interest and competency. A 30-inch tree is really hard to grow, not very hard. And so I do think we need a large carrot to make sure that folks don't bring it down, because at the same time, a quarter-acre lot in the city of Asheville is like $200,000, right now. So a heritage tree in and around that site, you know, it's pretty easy to say it's worth removing to make sure it's buildable. So yeah, trees are, with our land value, what it is right now, trees face a real uphill battle to be valuable to folks. It's just the reality of the situation. Also, as a side note, did we study at all what incentives may be possible to actually encourage canopy to be developed in empty parking lots where no development's happening? I don't know if that was part of this discussion or not. I know we're focused on heritage trees, but I would really like to see opportunities for increased canopy production. I mean, we saw that heat island effect map from NASA. I think that was distributed to us through public comment. And if you have an empty parking lot and no incentive to plant trees, you're probably not gonna.
Yeah, this is all triggered by development in Article 19, so undeveloped parking lots wouldn't get touched by it. It's a great idea, but it wouldn't be in this amendment.
Okay, well, maybe that's just a head nod to UFC then to do some creative planning.
Any other comments before we open for public comment? Thank you, Mr. Collins.
Thank you.
And at 7:58, I will open for public comment.
Hello, thank you. And Chris, thank you for clarifying.
Could you introduce yourself? Sorry.
I'm Christy Fiore. I'm on the policy working group chair on the Urban Forestry Commission. So I was part of the process of co-writing the amendments that are before you. Thanks, Chris, for clarifying an earlier communication we had. I think first, I want to follow up on that. I think in moving this forward, I think what was mentioned is that for heritage trees, there is an amendment in there for documenting the heritage trees on site, but there seems to, I think what would help this amendment would be to add something into 719-3 that just explicitly says that we are going to measure all heritage trees on site. And just to ensure those are all measured on the entire site. And then, in addition to that, I just want to say thank you all for bringing up all of your comments in support of the amendments and what could be possible in the future. And to kind of piggyback off of what was brought up at the very beginning of the meeting, I think one thing, by more collaboration between us all, and potentially having a liaison, I think we could really tease out a lot of the greater possibilities for ordinances for trees, but also making sure that they work for balancing all of the other goals that we have as far as anti-displacement and housing. So I look forward to hopefully getting something like that started up so we can collaborate on those issues. Thank you so much.
Thank you. Next up.
Good afternoon, or good evening, I guess I should say. I'm Patrick Gilbert, and up until about 2 weeks ago, with my resignation, I was a member and chair of the Urban Forestry Commission. I just wanted to give a little bit of context to what Chris has given you in his staff report, and Christy Fiore as the chair of the policy working group. As a member of the commission for 6 years, I was involved in the initial discussions with staff regarding the Tree Canopy Preservation Ordinance, Chapter 7, Article 19. And then when the City Council unanimously passed that ordinance in the September of 2020, the Urban Forestry Commission and staff agreed to monitor the performance of that ordinance and see if there was any room for improvement. So I think what's before you tonight is the culmination of almost 2 years of work between the Urban Forestry Commission and staff on this to make the tree canopy preservation ordinance better and help preserve our urban forestry canopy and all the benefits that that brings to the city of Asheville. So, thank you very much.
Thank you. Anybody else like to speak?
Hi, my name's Steve Rasmussen. I'm a member of the board of the Coalition of Asheville Neighborhoods, and I'm speaking on their behalf today. I also am the chair of the Rhododendron Creek Community Neighborhood Association in West Asheville. And I really want to thank you, first of all, for those of you who attended the UFC special meeting the other day, because that's exactly the kind of cross-pollination that neighborhoods need, because neighborhoods are where the rubber hits the road for just about all city policies and their consequences. So the statement that you received from CAN, from Rick Freeman, our president, passed unanimously because this ordinance amendment is very important to neighborhoods. I'll tell you why. These trees are critical to our so-called green infrastructure. One heritage-size oak tree absorbs hundreds of pounds of carbon dioxide a year. It prevents thousands of gallons of stormwater from, rushing down our streets and eroding our yards and so forth. And we have directly experienced, in fact, I have directly experienced the consequence of cutting down these, I should say my neighborhood has, of cutting down these size of trees. I live in one of the neighborhoods that NASA Develop and Davy of tree studies showed were been hit hardest by tree canopy loss. And one of the examples is there was a healthy, mature, very much heritage-size oak tree growing on a private property across the street from a small, older apartment complex in our neighborhood that perfectly fits the definition of missing middle housing. Well, it's been there since 30 years ago when I first moved there into that neighborhood. And one day the property owner decided to cut that tree down. I don't know why. But after the very next rainstorm, the kind of huge rainstorm we're getting under climate change, that parking lot of that apartment complex collapsed into a gigantic sinkhole. And not just once, but twice, because when they tried to repair it, it collapsed again. I mean, luckily nobody was hurt, but it must have cost someone a fortune. And that's the kind of unrecognized cost that comes from, a developer maybe making more money by cutting down that tree and then passing the cost on to the rest of us, and that's a form of destruction. Now, that tree wasn't on a property under development, so it wouldn't, have qualified necessarily as a heritage tree. But what if that owner, had decided to keep that tree and then sold it for development to some guy from Tampa who doesn't understand our southern Appalachian ecosystem here and how dependent it is on these trees? Well, that's why we need this ordinance amendment and, this kind of transparency, and just get it right there in paper. Do your best to save these trees. So thank you very much, and I hope you do collaborate more. I really, really think that's been very productive.
Thank you,
Thanks.
Mr. Rasmussen. Anyone else wish to speak? With that, I'll close public comment at 8:05. I appreciate you sticking with this long meeting. First of all, shows the commitment that we have in our community to improving our ecosystems as we grow and develop. Also appreciate the reference to Coalition of Asheville Neighborhoods statement that they provided us in advance supporting these changes. And from my standpoint, I just like to recognize that addressing our climate crisis and addressing our housing crisis are not mutually exclusive. We can do these things in tandem. We must do them in tandem. We have to accommodate growth and development within our city limits in order to address the consequences of sprawl and the environmental devastation that occurs when we don't build up within our city limits. We can do that while also addressing climate crisis and the livability that our tree canopy provides. So really appreciate all the feedback and work that's gone into this, and I'm happy to support this effort. Any other comments, questions, follow-up on comments before we have a motion?
I got to say, I really learned that UFC is a pretty fiery bunch. I like their attitude and their swagger to get things done. So really appreciated working with you guys, or you folks. Yeah.
Thanks. Would anybody like to make a motion?
I'll go for it. I move to recommend approval of the proposed wording amendments to Chapter 7 of the Asheville Code of Ordinances and find that the proposed amendments are reasonable, are in the public interest, are consistent with the city's comprehensive plan, and meet the development needs of the community, and that the amendment will 1, promote the usability of and make compliance with the provisions of Article 19 easier, 2, promote the protection of heritage trees on development sites, and 3, promote the efficient use of staff resources.
Would you consider adding to that the amendment I proposed about the 2X on the actual canopy size?
And for the amendment proposed by Commissioner Siegel.
Thank you.
Is that appropriate?
I second.
Will? Yeah. Understood. Okay.
We have a motion and a second. Any other comments before we take a vote? All those in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. So before we adjourn, I would just like to recognize Commissioner Bean. If City Council appoints 2 new members on September 10th, this will be
Which
your final.
I hope you do. I love you all, and I really hope you do.
Excellent candidates.
Terrific.
They're really good pools.
So just really appreciate your dedication to serving this commission and the city at large. Appreciate the insight you've brought, the awareness you've brought with Neighbors for More Neighbors, and look forward to seeing the good work that you continue to do out in the community with Mountain Trees. Thank you.
Appreciate it.
I second that motion.
I'll also say, as my first time, I mean, I've watched these meetings on like twice the speed many times while like just catching up on stuff.
The secret's out, twice
really
speed.
sitting through all however many hours is pretty substantial for a volunteer committee. So just really heartfelt gratitude. Like, none of us are doing this public service for glory. It's hard and it's a lot of work, and I'm just really appreciative. And can we feed them? Like, we should. I'm serious. It's a very different border commission. Like, we at least get dinner before we're here till 9 o'clock at night, so maybe we should talk about that.
Thank you.
Staff.
I second that motion.
Snacks. Just imagine if you started at 5.
Oof.
Yeah.
Yeah. General public? Well, we're done with the agenda.
I
Just
don't
for,
think you have to do general public comment.
we don't have to, we do have one member who stuck it out for 5 hours with us. Make it brief. I'll open for general public comment at 8:10.
While we're editing the
Also,
UDO,
Nice work to the public for being so enthusiastic.
I'll have you know that I didn't get here. I'm Marty Benson, by the way. I didn't get here until 5:15. Don't tell my boss, but I was watching for the last 2 hours of work before I came over here. While we're editing the UDO in the name of fighting the climate and housing crisis that we have, I was poking around in the UDO earlier today, and 7-11-6 is traffic analysis. And I'd like to throw it out. I know that some people might balk at not having traffic analysis for development. And in that case, what I'd like to do is reform that part of the code such that it reflects a goal of reducing vehicle miles traveled. level of service, which is currently the term of art in there, is something that should really be relegated to the Planning and Transportation Engineering Darwin Awards in history, because it focuses on throughput at a specific location and doesn't acknowledge that all of the development that we've allowed to sprawl outside of that location is actually squelching the throughput in that area. It belies a misunderstanding of induced demand, and it also shows an ignorance of the fact that you can't build your way out of congestion by building more capacity. One of the things that we like to say, one of the idioms in the transportation advocacy organizations is that trying to build your way out of congestion is kind of like trying to fight obesity by loosening your belt. And so I think that that section of the UDO could be changed such that it discourages increasing VMT and thereby would incentivize development that encourages walkability. So let's change that while we're at it. Maybe we can get some of this agendized by the city council someday.
Thank you, appreciate the comment. Anyone else? Thank you. I will close general public comment at 8:12. And with that, I would entertain a motion to adjourn.
Motion to adjourn.
Second.
All in favor? Aye. All right, motion, the meeting's adjourned at 8:12.